Matter for contempt, Your Lordships. Order was passed to enter my name in the revenue records the year 2022. Till date, they have not taken any action, Your Lordships.
Not by memo, it will be listed once you remove the office object. Yes.
Lordships, what has happened was there was a preemptory order. I filed an IA for recalling, Your Lordships, that I couldn't comply with the office objections. I filed an order IA for recalling. For that, I am moving this memo, Your Lordships, to comply the office objections.
IA for recalling.
Recalling.
Next Wednesday. Next Wednesday.
Please. Fresh matters for admission on cooperative election matter, my lord. My lordship directed me to move the memo after compliance of office objection. Office objection is complied. File is ready, my lord, for admission. Next week, any date.
So, appeal.
Appeal.
Be listed once you remove the office object.
Already removed, my lord.
Then don't worry. Don't submit any memo. Yes.
Writ appeal for admission, cooperative society election matter, while passing interim order by the learned single judge in the writ petition, permitted the appellants to cast their votes and contest the matter. While disposing the writ petition is rejected, liberty is reserved under section 70 to raise a dispute. The writ appeal is fresh matter for admission.
It will be listed. No memo. Once you remove the office object, it will be listed after 3-4 days or within a week at least. Yes.
And there is a mistake in final date in the order of the final order, my lord. For correction, I filed IA yesterday, my lord. It may be posted any day next week.
For
correction of date, my lord.
Spoken.
Filed IA, my lord.
Posted. It will be posted.
This is in respect of Gomad land, my lord. This is in respect of a Gomad land. We are the sheep grazers, my lord. Now, government has granted 60 acres of land for construction of power also. 7 acres is sufficient. I have challenged it under PIL. Yes.
Not by memo. It will be listed.
Another matter, my lord. It is a land acquisition matter. It was dispute for non-prosecution, and I was directed to say comply all the objections. I have complied with them. And now the matter has to be.
It will be listed. Not by memo. Yes.
Same to my lord. Hearing complied all the objections. ALR matter. There is a direction. They have not complied. So, tomorrow.
Not to. It will be listed. No urgency.
The lordships kindly, my lords.
We are ensuring that the matters are listed without any delay.
Before vacation itself, I have complied.
Wait for a week or yes.
The lordships kindly, my lords. I appeal for the respondent in the writ appeal. My lords, ex parte stay is granted. I filed an application for vacating the interim order. My lords, the matter is to be heard. My lords, it's a matter pertains to allotment of a petrol bunk. For 1 year, my lords, I've been paying rents to the land, my lords, in which the petrol bunk has to come up. Because of the interim order, my lords, the order of the learned single judge, my lords, is not implemented.
Some date is given.
Date is not given, my lords. No date is given.
After 2 weeks.
Pertains to
DPO
labor matter. The workman is a heart patient and his matter is not being listed. On account of a few office objections being left out, I seek kind permission of this court to allow me to comply with the office objections.
Comply with, nobody prevents.
The file has already been posted to be listed before the court only. So the lordship kindly grants us permission, we can comply with the office objections and then.
So there is nothing to be granted. You comply with. No permission.
Because the file is not being released. The file won't be released before being produced before the court.
It is lying where? Not traceable. Where is the file?
The file is in the before the pending branch. It will not be released because.
Then go and remove the office. What is the difficulty?
With the lordships kindly, my lords. A contempt matter, my lords. The order of the learned single judge, my lords, was to effect kata. The notice is already ordered. It was listed, my lords, last in the month of September 23. Any date, my lords, subject to your lordships.
So 3 weeks. Provided no date is
Date is not given, my lords. Last it was listed in the month of September 20. Obliged.
Last was listed on the month of
September 23. September.
Sir, mine is joint property, sir. The order is passed against adverse order passed without issuing the summons to the respondents and on the xerox copy of the impunged order. So I have filed this writ appeal, sir. Please post it. Yes. Yeah, fresh is posting.
He's saying what? This file to listed, not by memo. You remove the office objection and we list it.
I will remove.
Then there is no question of giving any memo.
Posted. It will be
It will be
posted.
posted in regular course, yes. Yes, anything, any further?
My lords, there's a contempt petition that I filed requesting for posting. I
You are
have a
appearing as
memo.
party in person?
Yes, my lords.
Yes.
It was last posted on 22nd of Jan 2024. The date on the online is blank, hence requesting for posting.
On that date, no date was given.
No date is showing up. 22nd first was when it was last
For 2
listed.
weeks.
Much obliged.
My lord, serial number 26 and 55, my lord. 26 and 55. 26 and 55, my lords. The connected matters. I seek a small adjournment.
What is it? What is 26?
My lords,
Well-
it's calling into question the order of reversing the order of bifurcation.
When do you want?
2 weeks, my lord.
2 weeks, after 2 weeks. So in the week of 24th.
Both matters may be connected, madam.
Yes, ma'am.
26
and
as well as
50.
55, madam.
They need to be connected.
Serial number 9.
Simply said, without any order. Simply. Yes,
Serial number 9, my lord.
9, yes.
For an adjournment of 2 weeks, my lord, there's some inconvenience. Adjournment for 2 weeks, my lord, there's some inconvenience.
9.
Yes, my lord.
Let it be called out.
My lord,
You are seeking.
there's some inconvenience. Seniors unwell, my lord. 2 weeks time may be granted.
11th July.
Please.
At the request of 9, at the request of learned advocate for the petitioner, must tend over to 11th July.
My lord, serial number 59.
Yes,
Serial number 23.
23, yes.
Wait for week time.
Why?
Because I'm not well today.
Not well. So 24th of June, stand over to 24th June, 23.
Grateful.
Serial number 59, my lord.
59, yes.
2 weeks may be granted. Paying for petitioner.
What do you want?
2 weeks, my lord.
2 weeks. Why? All right, 2 weeks. That is only go to 10th of July.
Much obliged.
Stand over to 10th of July at the request of learned advocate. In all at the request of earlier also. Learned advocate, you have appelled. Yes, any other mention?
For complainant,
Notice returnable.
that the violation
July.
of the order, para number 7 and 8, Milad.
Yes, notice 10th July.
Notice. Serial number 2.
Don't want notice.
From March.
You- you
Last
know-
time notice was issued, Milad.
Earlier it was issued.
Earlier notice was issued.
I don't know. There is no notice.
Yes, it is.
Number 2.
Lordship appearing in item number 2, ladies.
Ballot for the complainant, ballot.
So that other matter you were referring to is.
Uh,
not
Lordship,
previous
I'm-
one.
Ballot, I had mentioned about
learned
about two
single
writ petitions being.
So
allowed.
we'll issue notice here.
Yes, 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 ballot. Much obliged.
Notice returnable on. When shall we give? 9th July.
Much obliged, ballot. Much obliged.
Not 9th July. This is visitors. Right?
Grateful, Lordship. Grateful.
13th June.
Lordship, a shorter date may be given.
13th June.
Much obliged, ballot. Much obliged.
Grateful. Grateful. Grateful.
Number 3. Shivarudrappa Shetkar.
This is a direction not to comply the order within 2 months. It's 2 months have expired in the month of not 22nd April. It's to enter the lots the name of the petition and the revenue records. Para 13 of the judgment lots, second round of litigation lots, first round of writ petition was filed. Other writ petition was filed. There is a direction lots. Still there is no compliance. Para 13 lots. Consequently, writ petition is allowed. The impugned endorsement dated so and so is set aside. Response.
Notice.
While directing response.
8th of July.
So a shorter date not so a shorter date not for compliance. They have not filed any writ appeal, not still.
8th July. Shorter date you want?
Not
You want shorter date?
not.
18th July.
4 weeks.
Not 18th July. Yes.
4.
This is the matter wherein your lordship direction is issued the respondent, the accused number 1 to issue the caste certificate, your lordship. I obtained,
Yes.
there's some urgency, may make 17. There's some urgency. What has happened is, your lordship, I obtained a seat in National Law School of India in Bangalore under a ST quota. Now what happens is, because my seat will be cancelled if I does not produce the caste certificate.
Appeal is not filed.
No, my lord, appeal is not filed. Your lordship, may kindly see the email sent to the sent by the university, wherein they say that if I doesn't
Returnable on 12th June.
but only thing is, because
When the admissions are going to finalize?
no admission, because I obtained the seat, your lordship, unless I produce that certificate, my seat will be cancelled because I cleared the exam.
Which date do you want?
Lords, the Tashildar is present. The thing is, in this matter, my lords, the Tashildar who is grade 2 Tashildar, he is the officer who has to issue the caste certificate. Let them implead. Now, as per my instructions, since this is an education matter, tomorrow, they mentioned that tomorrow is the last date for submitting the caste certificate.
Is it so?
Yes, your lord,
That was
tomorrow
when
is the
them,
last.
Government advocate saying that the competent authority is different.
competent authority is different, but he is present
State
here.
authority.
Grade 2 Tashildar, we shall ask to be impleaded. He is present
Who
here.
is present, please? Higher or slower?
Grade 2 Tashildar is also present, and the
No. Then is present and instructed your business. Comply with the order. Irrespective of they being party. The higher officer is there. State is there. State is there.
Yes, state
They are
is
the
there.
officer of the state.
Please.
Comply with today itself. Come with the certificate at 2:30. If the last date is tomorrow. For technicalities will not govern.
Please.
Your state, all our officers, instruct them to issue the caste certificate.
Please.
Unless, of course, you are filing appeal. That's a different. 2:30,
Please.
take instructions.
So PL matters, number 5, Mr. Kiran J.
Appealing for the petitioner, my lord. My lord, the petitioner herein, my lord, issued a representation, my lord, for the Tahsildar under section 66 of Karnataka Land Reforms Act, stating that there is an excess land. Please, my lord. My lord, my case is that I've given a representation, my lord, to the Tahsildar stating that under section 66, my lord, there are certain people are holding excess land. My lord, which as per section 66, my lord, there is a limit to hold the land, my lord, which the certain people are holding excess land. I gave a representation to the Tahsildar, my lord, to refer the matter to the tribunal, whether to take action as per section 66A. My lord, that was not done, my lord. Earlier I filed a PIL. My lord, this honorable court directed the Tahsildar to consider my representation and pass appropriate orders, which was not considered, and my lord, I filed a contempt petition. My lord, in the contempt petition, they filed an endorsement, my lord, stating that there are certain civil disputes. My lord, my grievance is that, my lord, as per section 66A, my lord, the Tahsildar does not have jurisdiction. He has to refer the matter to the tribunal. Tribunal ought to have taken a decision. This endorsement by the Tahsildar, my lord, does not survive for consideration, my lord, is my argument, my lord, before this honorable court. He does not have authority to, my lord, that endorsement was challenged before the single judge, my lord. Earlier, my lord, we filed a PIL. In view of that, it is in a larger interest, then granted liberty, my lord, to file the PIL. My lord, that is the order at page 54, my lord, Annexure E. Annexure E, page 54. My lord, the operative portion, my lord, is at 59. 59, my lord, paragraph 2. May I read that, my lord? Section 67, subclause 3, my lord. My lord. Annexure is. My lord, my only grievance is that, my lord, the Tahsildar would not, straight away he has to refer the matter to the tribunal, my lord. He has taken a decision. My lord, in the previous round of litigation, my lord, this court direction, my lord, was to conduct an inquiry and pass appropriate orders. My lord, when we file a contempt petition, my lord, straight away come up this endorsement, which is not maintainable, my lord, to have taken a decision, my lord, and refer the matter to the tribunal. That is my only grievance. My lord, if the matter referred to the tribunal, my lord, I would have. Annexure C, my lord, the earlier order, my lord, page 46. At page 49, my lord, the specific direction, my lord, Tahsildar, my lord, consider the representation and pass appropriate in accordance with law after notifying respondent number 5 and 6 in this regard. Please, my lord.
Great.
Cell number 8. Richard. Mr. Prakash BS.
Ramesh, yes, please.
Please, my lord. The order referred to I have brought, my lord.
The application which are filed prior to 2016 shall be considered. Considered. Eight B1 of 2016. In the year 2016 itself. 8B1 clearly says all the pending application become ineligible. Ineligible. That is 8B1 of 2016. No, subsequently it has been amended on 17/3/2023. 8B has been substituted. Yes. Eligible. They made it as eligible by this amendment. This application was made prior to 2016. And pending. What else? A to B. My submission is large. In the from 12/8/2016, by the virtue of 8B1, all the pending application by operation of law deemed to have become ineligible of 8B1. Prior to 12/8/2016.
Page number. Page number.
Page number 53. If where. In this case, what had happened was in this case, what had happened was, I want to clarify. In this case, since by the virtue of this order of setting aside, this become eligible. That is the only place. Pending application, all pending. Early 8/2016.
Please. Alright.
Three, four, eight, double two.
Timeline.
Not 6 months, because not, they have to obtain no objection certificates from various authorities. Will do, because they'll hold us for contempt, and if the no objection is not rendered.
We will not do that. We will not do that.
Obliged.
Grateful, my lord.
number 6. Mr. Nagaraj NR. Mr. Nagaraj NR, number 6. Number 7. Mr. Nandish Patil.
Lord, this is a writ petition, my lord, where I'm seeking for a mandamus to consider my representation. Lord, the petitioners, my lord, are residents of Tawargi village. My lord, they had given a representation, my lord, to the deputy commissioner, requesting him not to permit opening of a liquor shop in the village. Lord, that has not been considered. Lord, representation, Lord, is at page 45. Please. Lord, in favor of my lord, the respond number 6. Sir, my lord. No, my lord, we have said
Patta lands, my lords, which has granite deposits. The present rule, my lords, Rule 32, Sub-Rule 10, my lords, deems that all working permissions granted prior to 2016, my lords, are to be considered as quarrying licenses, my lords. We have made an application in 2023, my lords, June 2023, seeking for a grant of quarrying license, my lords. Till today, it has not been done.
Lord, my submission is, we'll consider page number 15.
Sub-Rule 10, my lords, of Rule 32 of Karnataka Minor Mineral Concession Rules, my lords, it says all working permissions granted for ornamental stone quarrying in private or patta land before commencement of the Karnataka Minor Mineral Concession Amendment Rules 2016 to be considered as quarrying license from the day of commencement of these rules, provided that the jurisdictional deputy director or senior geologist shall issue quarrying license in Form E, and licensee shall register the same as per Rule 18 of these rules. My lords, now the jurisdictional deputy director or senior geologist, my lords, has to issue the quarrying license. He is not issued, though we have made an application, my lords, in the year 2023. We don't even have to make an application, as my humble submission. In view of Sub-Rule 10, statutorily, they have to be considered as quarrying licenses. And the only thing that is left to be done is issuance. A physical copy has to be issued and we have to get it registered. Now we've made an application also, which has to be considered as a request to the authorities to issue a license to us. My lords, they have to issue a license to us and we have to get it registered, my lords. That is the only thing that is left is my submission.
And that's incorrect submission.
Is not issued, though we have made an application in the year in.
They're bound to make an application, not under 32(1). They have made an application now. The submission that they need not make an application and it has automatically it has to be converted is incorrect. So far as 32(1) mandates that they shall file an application. They have filed an application. We will consider it in accordance with law.
Rule 10 may kindly be looked into, my lords. All working permissions granted for ornamental stone quarrying in private or patta land before commencement of the Karnataka Minor Mineral
My
Concession.
submission is, prayer 1 may be considered, granting 6 months time. Will
not 6 months, my lords. It's
in accordance with law.
Not 6 months, my lords. It's just issuance of license. We have all the clearances and the environment clearance, scheme of quarrying, everything we have submitted, my lords. Let it be within a month, my lords. That is my submission. Pardon, my lords? My lords, application could be a formality. I have made it.
Sub-rule 1 of Rule 32 may kindly be seen.
It's a formality, we have made it.
It's not a formality. They're bound to make an application
It's
for
a-
quarrying license.
It's a formality. That's my submission. It's a formality because sub-rule 10 says if there is a working permission granted prior to 2016,
starts with
in the instant case, it is granted. That's my submission.
That is true. Lord, from 12/8/2016, with working permission, the quarrying cannot be conducted.
Correct.
They have to obtain quarrying license, for which, Lord, they file an application in Form E.
We've done.
They have filed an application. They have filed an application in Form E. All that we have to consider that application. We'll consider it within a period of 6 months.
They cannot
Because, Lord,
consider is my submission. They have to grant me quarrying license. That is
because,
all my
Lord, they have to.
submission.
Yes. Lord, your Lordship, kindly see. The sub-rule 6 of Rule 32 may kindly be seen. Now, statutory requirements. Not about their entitlement. They have to fulfill, Lord. They have to provide all statutory compliances, Lord. Yes. The provisions of Chapter 2 and Chapter 2A and Rules 13, 15A, 17, 19, 19A, 19B, 19C, and Chapter 6 of Chapter 7, Chapter 8, and Chapter 9 shall mutandis apply for grant of quarrying license under this chapter.
This is grant of quarrying license. If I make an application for the first time, I already have a working permission from 2012. That is my submission. I've been working from 2012. Kindly see, my lords, my working
Not
permission.
my submission here.
25/20/23.
Under-
The working permission which was granted in 2012 is transferred to my name. So there is a working permission prior to 2016 amendment, and hence they have no right to reject my application or consider further. And I have provided all the statutory compliances, my lords. Environment.
It is all we
certificate-
wanted.
Yes.
Yes, that's
We cannot say no to the conditions imposed. We just saying they cannot refuse to grant us quarrying license. Well, we have made a formal application. An actuary is a formal application we've already made. I'm just saying it's a formality. They have to just consider it and grant. We've already made.
They have made an
We made
application,
it.
Lord.
Page 51. There's no controversy.
There is no controversy. They have made an application, Lord. I made that submission.
$51. Six acres, 3 guntas of land.
That's,
Yes, madam.
yeah.
Yes, please.
Working permission.
Please.
Lord, in this particular
License.
case, it is 32, rule 32 only. In this particular, rule 32.
To issue quarrying license within
6 months.
my lords, it's my own patta land. I
Statutory,
have.
Lord, if they have furnished everything, Lord, we'll decide it immediately, Lord, because no, Lord, because the reason is this, Reason is this, my lord, if they were having working permission in the year 2010, then EC was not the requirement.
We have
Only
we have the EC.
No,
We have the EC.
no, my
That's why I
submit-
produced everything for consideration of my.
Let me submit. In the year 2013, forest clearance was insisted upon. That is the reason I am submitting, my lord. If they have everything, we are going to issue within 1 month.
There is no
Otherwise,
forest
my lord, we
anywhere
have
near
to
the lands,
procure.
my lords.
We have to procure those statutory requirements from the concerned authorities.
We have obtained the environment clearance.
No, if that is there.
Academy. We have obtained all clearances, my lords. We have a scheme of quarrying. The only three requirements are conversion of the land, scheme of quarrying, and environment clearance certificates. We have produced all the three in the petition itself. 2 months, my lords, not more than that. They won't require so much of time, my lords. They can't. Please, please. Oblige.
Oblige.
Is number 11, Mr. M.M. Swami.
Could I appeal? But I am the owner of 2 lands, my lord, bearing survey number 13 and 15. I've got both the lands converted for the purpose of establishing a stone crushing unit. Earlier, my lord, the authorities had given me the license for a period of 5 years. My lord, earlier the rule was, I have produced, in fact, my lord, at page 29, the Karnataka Regulation of Stone Crushers Amendment Act 2013. Not earlier, in fact, earlier to this amendment, the minimum extent of the area, my lord, for which a stone crushing unit to be established was less than, there was no limit. Now they have made it 1 acre. Minimum I should have 1 acre. Earlier there was no limit. Now by virtue of this amendment.
2 acres in respect of quarrying lease. This
Quarrying
is crusher.
lease. This is stone crushing unit. But now, in fact, I have obtained the conversion also of my adjacent land. Both together, my lord, it exceeds, in fact, 2.45 acres. Now they can consider that.
This was rejected in the year 2010 itself. Form D was issued.
20, not 10, 20, sir. I had a license up to March 2024.
2020.
Pardon?
39 is the rejection.
Now, in fact, my lord, by virtue of the time, my license has expired in March 2024.
Date is wrong.
Date is
wrong, but
Date
lord,
is
it
wrong,
was
it is not.
rejected in the year 2020. There is a delay of 4 years, and moreover, it is a appealable order. There are 2 aspects. One is delay. Another aspect is, lord, it is appealable order.
During the existence of the license, my lord, this has been rejected. I had a license, my lord, in fact, which was valid up to 2024 March. Now my license recently has expired.
That has not been challenged so far. 2020, it was rejected.
The time it has been expired.
Rejected. He slept over the matter. Lord, in the year 2024, he's filing the writ petition.
Kindly, in fact, look at, my lord, the representation which I made in 2020 itself. On 29/2/2020, I made a representation by Annexure D.
What is the period for
License.
filing appeal? Limitation.
Now, my lord, this order, my lord, kindly, in fact, look at the order.
Please
This does
answer.
not, in fact, state that I have been heard. I am not.
Please answer what is the period of limitation. It has great relevance. whether we entertain the appeal petition or not.
No, for the purpose of filing the writ petition, my lord.
What is the period of limitation for preferring the appeal against this order at page 39?
No, there is no appeal.
There is no.
Section 15 of Regulation of Stone Crushers Act, 30 days.
Section 50, Rule 15, Section 15.
Section 15 of
Appeal.
Regulation of Stone Crushers Act 2011.
Communicated to the person. When it was communicated?
No, I've not been communicated at all, my lord. Your lordship may kindly see the order itself says that it is without notice to me. They have just, because after extending the license by virtue of the order passed by this Honorable Court, I was not even issued with any notice. They have taken a decision themselves. Look at the impugned order, my lord, kindly. In fact.
Anyway, now you are aware.
Now I am aware immediately after coming to know about the, because my lord, I wanted to.
So one of the principle is that you can't invoke the jurisdiction in respect to order which is available and the
Suppose
period of
if it is
limitation
there,
is over
if
to
it is-
circumvent the period of limitation.
But if it is passed without notice and without
If we
hearing
entertain
me,
your
I
petition,
think I am
it will be
entitled to file a writ petition. Notes.
Statutory period will be circumvented. That is not permissible
Statutory
for the
period
writ
only
court.
14 sections, sir. Really, sir, sections, sir.
15.
15.
This is
Amended Act.
this is what green bench.
It is,
Green.
Milord, kindly, in fact, Milord, look at the, this regulation, Milord, kindly at page 29 and 30. There are only 14 sections. This is amended Act, 2013 amended Act. What is the time limitation? This is section 15. 14. This is 11, sir. 11.
11, 15 is not required. It's there in the statute.
Find it in 2013. In 2013.
So it is condonable also, 30 days. Proviso.
Only for 30 days.
11, heard learned advocate, sorry, Mr. Swami. Heard learned advocate, Mr. Swami YMM for the petitioner and learned government advocate, Mr. Mahindra for the respondent state and its authorities. Respondent state is there. Yes. What is read in this petition filed under Article 226 of the Constitution, is to set aside order dated 25/6/2020, passed by this fund number 3 dash as sensing and regulatory authority of district crushing units, Chikkaballapur district. Thereby the decision is communicated, decision is taken by the licensing and regulatory authority to reject the application of the petitioner for setting up the crusher unit. any of the grounds on which the court is not inclined to entertain the petition, the court is not delving into the merits of the reasons supplied by the authority while passing the aforesaid impugned order. Firstly, the order was passed on 25/6/2020. The same is sought to be challenged by filing this writ petition after a yawning gap of 4 years. Full stop. For this long delay, no satisfactory explanation is furnished. Even otherwise, after passage of 4 years, the court would not be inclined to entertain the petition. There is a weightier reason not to exercise the writ jurisdiction. Full stop. A remedy of appeal is available to the petitioner under Section 15 of the Karnataka Regulations of Stone Crushership Act 2011. Full stop. Section 15 provides for appeals against the orders of the licensing authority. To say that the regional commissioner of the concerned region shall be the appellate authority of respective jurisdiction to whom the appeals in respect of the orders passed by the licensing authority shall lie. Full stop. Subsection 2 provides the limitation period of 30 days and the proviso thereto makes the limitation condonable provided the sufficient cause is made out. Paragraph. When the statutory appeal is available to be sorted to by the petitioner in respect of the order impugned in this petition, the court would not exercise its jurisdiction. For both the above reasons, without going into the merits of the case, the present petition is dismissed. Stop. If it is permissible for the petitioner in accordance with law to avail the remedy of statutory appeal, such liberty is reserved.
Seal number 12, Mr. Jayasimha.
The petitioner is owning 3 acres and 22 guntas of land.
Yes.
A portion of his land comes within the Ramadevara Betta vulture wildlife eco-sensitive zone. Manods. Initially, the petitioner had proposed to set up a Tata Motors car dealership in the premises, Malods, and had applied for permission. However, that permission was rejected. Thereafter, the petitioner has submitted a fresh proposal, Malods, in accordance with the notification, Malods, where the petitioner is now intending to set up a training institute, Malods, which comes within, in fact, activity that has to be promoted, Malods, and is intending to set up an automobile service station without discharge of trade effluent, Malods, which comes within the green category, Malods. Without considering this revised proposal that has been submitted at Annexure G, Malods, the respondent has been issuing notices, Malods, threatening coercive action under 19 and calling upon the petitioner to demolish the pre-existing structure within his premises, Malods.
So this is the only notice.
Malods, I'm only requesting for a stay, Malods, for this reason, because repeatedly, Malods, coercive notices are being issued, Malods. When the revised proposal has been submitted.
Anybody appears?
Notice is not served.
Malods,
Advance notice is not served on us.
No, you view no copy in advance to the council for the state government.
Malods,
Now
the
this is
deputy-
premature. This is a premature petition. Only notice is issued. You can approach the authority and explain your stand.
Malods, the revised proposal is also submitted, Malods, after the revised proposal at Annexure G.
About what?
Malods, regarding the proposal to now set up a training institute, Malods, and seeking permission, without considering the revised proposal, Malods, basis the earlier proposal that has been made, coercive notice is issued under 4.3, Malods.
What are you praying? Only to set aside this notice?
My lord's also seeking stay and
Set aside the notice.
under mandamus to consider the representation that has been
Then
made.
to
my lords.
respondent to consider the petition proposal. What is the proposal?
My lords, the proposal is at annexure G, now to set up a training institute, my lords, which comes within the activities that has to be actively promoted, my lords. And for setting up a automobile service station, my lords, without discharge of any trade affluents, which comes within the green category, my lords.
Notice returnable on 27th June.
Deeply obliged, my lords.
Number 13. Sukumar KV.
The petitioner is seeking for writ of mandamus to consider his representation produced at annexure A, my lord.
Is it permissible?
Please, my
Transfer of working permission is
Yes,
permissible.
my lord.
Under which provision?
My lord, the transfer, my lord, there is a legal opinion furnished by the department.
Legal opinion, don't cite somebody's legal opinion, that to an officer. You are citing before the High Court. You may produce it, but don't rely on the legal opinion. We are not going by the legal opinion of anybody, except our decision. What is this?
My lord,
This is out of propriety, mister. You may annex it. That's a different thing with the memo of petition. But you are pressing and persuading on the legal opinion of some officer.
1 minute, please. My lords may now kindly
And that
see.
too before the High Court?
1 minute, please. My lord, lords may now kindly see annexure B
No,
for
you show the provision.
annexure B, my lord, working permission was given
Provision.
in favor of
Provision
one.
in law you can show, then we'll entertain. Otherwise, you'll not.
My lord,
Provision of law or rules under which this working permission can be transferred to another party. If you show, then only we'll entertain the petition.
lords may kindly give me.
Not on the basis of the legal opinion of the officer.
Lord, my lords may give me 10 days, my lord.
Pardon?
I'll
Find out.
Lord, there is no provision because from 12/8/2016, the concept of working permission is not there.
Concept is not there.
Not there because they have to obtain quarry license under 32, rule 32.
So this you are holding working permission
Yes, my lord.
since when?
My lord, it is from,
Not the petitioner, is vendor.
my lord, she has approached the Honorable
So
Supreme
you
Court.
want transfer in your favor?
Yes, my lord.
That is out of question. That is out of question.
Lords may now kindly, in identical circumstances.
One time will give time, otherwise we are ready to dispose of.
Please,
and dismiss
lords may give me
right
10
now.
10 days time, please.
10 days time.
Please.
all right. Learned advocate for the petition 6 time. Even as the compass of the controversy and the issue involved was noticed in course of the hearing. Full stop. Acceding to the request of learned advocate, comma to the petition shall be listed on 11th of June, 12th of June at 2:30.
Please.
Seal number 14. Avinash Goda.
12th June, my lord.
Yes.
Avinash Goda.
Yes. Whoever. Keep it.
Seal number 15.
So mandam, the petitioner is seeking a mandamus, my lord, to consider his application, which he filed it, my lord, in the year 2020, seeking quarrying license in his private land. But in fact, after receipt of the application, my lord, the deputy director in fact informed the Tashildar to find out the status of the land. He was already given the status of the land as a patta land, private land, and there is no impediment for issuing a quarrying license. Similarly, in fact, the other authorities also, my lord, have been asked to give consent. And my lord, when I in fact tried for, when I got this land for converted for the purpose of conducting quarrying activities, the deputy commissioner in fact directed both the revenue department and the forest department to give a status of the land and also to give their objections, whether they have any objections. My lord, in fact, they conducted a joint inspection and found that, my lord, that land is fit for, in fact, conducting quarrying operations, and they have no there is no impediment for conducting quarrying operations in the land in question. In spite of it, my lord, the application is still pending consideration. And my lord, the authorities have not issued me the license. And it's a private land, patta land, owned by me and possessed by me. I've got it converted for that purpose also.
This is survey number 15.
Pardon? Patta land.
Patta number survey number 15.
Yes, Mr.
But then it is on your own saying it is notified as reserved forest.
No, it is not. 15 is not. 13 is my number.
13.
No, it is
Your-
not.
that
15 is
what we are-
notified for forest.
So your is what, 13?
Yes, my no, my survey number is 102,
10,
measuring
10.
2.36 acres. What has been notified is only survey number 15,
So
which is very far away from
To consider not in accordance with law within a period of
6 weeks.
they will consider. Yes. Our learned advocate, Mr. Swami MM, for the petitioner, and learned government advocate, Mr. Mahendra, for the respondent state and its authorities who appeared and assisted the court upon service of copy of the petition in advance. Referred under Article 226 of the Constitution. In this the petitioner is prayed to direct respondents number 2 to 4 to issue quarrying license to the petitioner for conducting quarrying operations in the land bearing survey number 102 at measuring 2.36 acres situated at Pura village, Aradan Ali, Hobli, Chamarajnagar Taluka and district. As per the application dated 17/7/2020 made by the petitioner. The case of the petitioner inter alia paragraph is that the petitioner is the owner of the said land and that he made application for quarrying license on 17/7/2020 before the respondent authority. The license is sought for extracting building stone. Is requested for extracting building stone. It is the say of the petitioner that the application was acknowledged by letter dated 20th/8/2020. It is awarded that the respondent authorities made certain inquiries also. It is further pleaded that after receipt of the application of the petitioner, the deputy commissioner by communication dated 22/2/2021 requested the forest conservator and the Tehsildar Chamarajnagar to conduct a joint inspection and to submit the report. Paragraph. The case of the petitioner is inter alia that the land in question on which, in respect of which the quarry license is applied, is a patta land. Which solely belongs to the petitioner and is null, and that it is not notified as forest land requiring any forest clearance. It was stated that the surrender of land was never treated as forest. Surrender petitioner was never put forest or was never treated as forest land by the forest department. On the basis of all the above submissions, it was said that when the conversion of land for use of non-agricultural quarry purpose was also permitted, there was no reason for the authorities to not to grant the, not to issue the quarrying license. Paragraph. All the above facts and aspects are required to be considered by the competent authority, before whom the application of the petitioner dated 17/7/2020 is pending for approval decision. It is for the competent authority to look into and inquire whether the petitioner's application satisfies the parameters and requisites for grant of quarrying license. Full stop. When the application is pending and the decision of the competent authority is awaited, this court would not issue any positive direction for grant of license. It is the function of the competent authority. Therefore, this petition is disposed of by directing the competent authority respondents to consider in accordance with law application dated 17/7/2020 of the petitioner for grant of quarrying license on the land in question in accordance with law and on its own merits, taking necessary decision within a period of
3 months.
3 months from the date of receipt of the order. This petition is accordingly disposed.
Number 16, Mr. Ramchandra.
Yes, sir. For grant of lease, 20 untas of land, Mayasandra village, Devanalli village. Annexure B, my lord.
One submission, Lord, before my learned friend. The prayer is to Lord consider their application that has been rejected in the month of January itself.
Reject. It was not communicated. Even I have filed an application during February 2022, 24. My lord. They have not communicated the.
For the
even
reason, Lord,
They are communicated.
seeking quarry lease in an extent of half acre, not required area is 2 acres as per the amended rules.
The only prayer made in this writ petition, write down. Nothing, sir.
No, no, that is true, man. Liberty may kindly given. You have not given the.
You are at liberty. The things arose in, sorry, this the only prayer made in this petition is to direct respondent to authority. Respondent to, as Deputy Director, Department of Mines and Geology, to consider the application of the petition dated 12/9/13, whereby the petitioner wanted license.
Yes, lease, man. Lease. 20
wanted the grant of requested for grant of quarry lease for building stone in survey number 63 at Mavasandra village, Devanhalli Taluka, Bengaluru rural district. Post of. When the petition comes up for consideration, learned government advocate Mr. Mahindra made a statement by producing order dated 11th January 24 that the aforesaid application dated 12/9/13 was already considered by the competent authority and the same was rejected. Post of Xerox copy of the said decision is produced, which is kept on record. Post of the factum of rejection of the application could not be disputed by learned advocate Mr. So and so for the petitioner.
In view of this rejection,
however, he submitted.
liberty may kindly.
Liberty may be reserved for the petitioner to challenge.
To file an application for 2 acres is limited, because I have 20 guntas is out, but according to them, 2 acres is minimum. I can even that.
Challenge this, you want to challenge this?
No, I'm permitted to file a fresh application for
No.
for 2 acres. It is the Goma land is available still.
How do you file a petition, separate petition?
Yes.
At this stage, law and advocate to the petitioner prayed for liberty prayed for reserving liberty for the petitioner to challenge. Therefore, she ordered it at 11/4/24. Full stop, such liberty is reserved to be exercised in accordance with law and on its own merits. Although this court does not express any opinion in respect of such recourse to be taken by the petitioner, the petition is disposed of accordingly.
Writ appeal matters, seal number 17, appeal by government.
Notices have been issued to the respondents for recovery of the
On the ground that he completed PhD, the benefits are recovered. On the ground that the PhD was completed after the discharge period.
Yes. There is, I make one submission. There is a little distinction in this appeal.
Yes. What is the distinction?
Respondents have been appointed as associate professor. The condition of appointment was, if I'm not going to take page 98, document number 6 at next page, my lord, page 99. This fact was not brought to the notice of the learned single judge, my lord. The two decisions which the learned single judge has referred to don't apply to the case of the appellants, my lord. There's a slight distinction. Notice could be issued, my lord, then I will be able to convince my lord. No, my lord, delay of 286 days.
Notice written alone. You all are appear in this matter? No. Which date shall we give? 1st July? 1st July.
Seal number 18, Shrimati Anusha L.
This is a case where
I appear for the first respondent.
the age of superannuation prescribed by the state government under Article 309 would prevail over the UG's regulations. This question, has been already considered by this court, and the matters have been referred to the full bench.
This is pending before full bench.
Yes.
Then why?
Yes, madam. Appeal for this point.
It was stated that the issue involved in this writ appeal is pending consideration before the full bench of this court. In that view, adjourned. Also, the appellant may move the court.
Shall I furnish the numbers
after the decision of the full court? Yes.
Number 19. M.E. Nagesh.
Appear for opponent. This case I pray for 2 weeks time. Reason is this minute. I filed writ appeal on 23/3. On 29/3, government has made one more amendment to the Motor Vehicles Act that allowing the private operators to get variation even on scheme route. That is on 29/3/2023. I have to produce this application.
So your authority, who are you?
I am the petitioner that is applied for grant of variation of my conditions of my permit. That was rejected on the ground of scheme. Now the scheme itself has been amended on 29/3. That is why as per the notification.
Scheme is scheme for
That
case
is-
permit.
That
It's
is
amended.
schemes are amended.
So then this will not survive.
No, that is.
Why should it survive? Press things will operate. This decision will not survive any of the new scheme.
Lots of
This
kindly.
decision will remain to nobody's advantage or detriment.
And I am, at least I am, as per this amendment, I am entitled now.
Very good. Then. Go before the authority.
Lots of kindly liberty this one to approach the authority for as per the, yes, I am filing a memo to the tech.
Yes, ma'am. Yes, Miss. Madam.
No, this, I'm producing this memo, my lord, notification. Memo, you can memo, I am writing it. I am permitted to withdraw the petition and pursue as per the amended dated 29/3/2000. In the last lap of the judgment of the learned single judge, what it says. This contention by merely referring to the third proviso to section 88 without referring to section 104 of the motor vehicle is also liable to reject it. 104 refers to the notification of signing.
Learned advocate for the appellant, when the appeal was taken up for consideration, submitted a memo dated 30th/5/24. Full stop, paragraph. The memo reads as under, then quote the memo. It is here. Paragraph. In view of the above memo, learned advocate for the appellant does not press the appeal. Full stop. He is permitted, the appellant is permitted to approach the competent authority of state government for seeking benefits
For
of
the authorities, madam.
benefits of new scheme envisaged in notification dated 29/3/2023, comma. The case of the considered may be case of the petitioner, that's all, disposed of accordingly.
Yes.
Dispose of, the appeal is disposed of as withdrawn in view of the memo.
So number 20, 21,000
Here for the appellant's counsel, my lord. This is a matter arising from a decision of the learned single judge, which is challenged by other petitioners in writ appeal number 726/23. And the matter has been admitted by this honorable court, and status quo order has also been granted
By Apex. This court.
this court.
Similarly.
Not this page, another.
No, but in respect.
Similar matter.
Similar.
Arising from the same.
Before my lords, my lord, there is no such order as far as I know that has been granted. But,
I am producing the order.
no, I didn't say, I'm not disputing your, this thing, before my, if, whether my lord has passed the order.
So in one of, this is a common order.
Common order, my
So in one of the petition, the appeal was filed and that is what's. The present appeal arises out of common judgment and order dated 22nd May 23 of learned single judge. By which different by which writ petition number 11, by which writ petition number 1115 of 13, with writ petition number 43928 of 12, 11966 of 13, 23287 of 13, and 62434 of 16 came to be dealt with and disposed of. When the present appeal was taken up, when the present appeal which arises out of the state common judgment in so far as it related to Read petition number 23287 of 13 was taken up from a learned counsel for the appellant stated that the same judgment and order of learned single judge has already been subjected to writ appeal in relation to another writ petition and the division bench and the coordinate bench has stayed
Please,
the order.
the status quo has been granted.
We said the same order will apply to the present case also, full stop, as provided in the cognate appeal, being writ appeal number 726 of 23, aforementioned, the parties are directed to maintain status
Please,
as on today, till further order of this court.
this case may be called with that
Both
case.
the present appeals are listed with writ appeal number 726 of 23.
Public.
All, yes, all. Another cognate. Yes.
Number 21, Mr. Akash VT.
I appear for that there are two writ petitions in respect of it, a common order has been passed by the learned single judge. We have filed two writ appeals. One writ appeal has come, the other writ appeal also has to be posted because one relates to seniority list, another relates to the promotion to the post of associate professor.
It was stated that the cognate writ appeal number 224 of 23 is required to be posted along with the present appeal. The registry is directed to list both the appeals together on 4th of July.
Number 22.
Any date in this month, June,
June.
because he is posted as promoted as associate professor.
The promotion can wait anyway, June, 24th June.
24.
Number 22, Mr. Balraj, yes, sir.
My lord, I appear for the appellant, my lord. My lord, the order of the learned single judge dismissing the writ petition, wherein, my lord, on the ground of delay and laches in, normally there is an amendment to the act. And my lord, the similar issue,
Matters are pending in writ appeal 210. and
210 of 2023.
What is it about?
My lord, similar matters, my lord, are pending, my lord, with
When the group is kept?
18th.
18th of June.
June.
To be listed with 18th of June along with.
My lord, there is an order of, I have sought for status quo order, my lord. I have prayed for an order of status quo, my lord. In similar matters, it has been granted, my lord.
Granted.
And it's
studying in
passed
the
in WA 210 of 20.
Is there no coercive state? What is the order? Status quo? As in the early, not as, since in the other cognate petitions, the interim order is passed, in the present case also, it is directed that, it is directed by interim relief that, where is the order?
My lord, in first para itself, my lord. On 12/3/24, since all the matters are going to be listed on
Parties to the proceedings are directed to maintain status quo with regard to the subject matter land till the next date of hearing.
Please.
23 urgent, number 24, Mr. Satish K.
I appear with the council for the appellant is a society. Registered Societies Act. On 7/12/2004, the order is passed to hold election excluding 35 members. Some of them approached the civil court for declaration that that resolution is bad. I'm not. It is wild. By Annexure G, page 93. Civil court declared that as far as those petitioners are plaintiffs are concerned, you have to include the name in membership. We have included. Others who have not approached the court, this court, learned single judge says, my lord, annexure G, civil court judgment is in rem, not in personam. But section 31 of the Pacific Relief Act is very clear. Judgment is in personam.
Which judgment is in rem, according to learned single judge?
Annexure G, page 93, civil court
90
judgment.
93.
Yes, my lord. He says this judgment is rem.
And on
include
that basis, the relief is granted.
What?
On that basis, the relief is granted.
Yes. He relied upon this judgment, says persons who have not approached the civil court for declaration, they are all members because this judgment is rem. It is bound, you are bound by this judgment.
The judgment is by civil judge.
Yes, my lord. Only 4 persons.
Never been rem.
Section 31 of the Pacific Relief Act is very
My
clear.
lord, may I respectfully,
Judgment can't never be.
my lord, may I respectfully submit?
Civil court is always deciding
Yes, my lord.
rights between parties.
My lord,
It is only the writ court which can deliver the judgment in the
Yes.
not civil court.
my lord, in the said proceedings, my lord, a categorical finding had been recorded.
So
By-
that is the reason. Let us see.
Please.
My lord, para 5, I will read. Having heard the page 34, having heard the learned counsels, having pursued the petition papers, this court finds that judgment passed by civil court, that is annexure G, true at the instance of 3 newly inducted persons, would be an order which would benefit all newly inducted members, kindly note, not restricted to the plaintiffs. In fact, this observation has been made found place in the subsequent judgment of this appellate court, wherein it was rightly held that resolution dated 15/9/2020 is a legitimate order, resolution, judgment passed by the trial court was upheld. Yes, I filed appeal. In appeal, it is upheld. In consideration of the opinion of this court, there was no need for the deputy registrar to direct holding of one more inquiry under section 25, since legality of the resolution dated 15/11/2003 was already decided by competent civil court, that is annexure G. The only issue was required to decide whether benefit of the judgment passed by civil court would inure the petitioners, inure to the petitioner herein all the members whose name found place in resolution 15/11/2003 as noticed here and above. The first appellate court has rightly held resolution dated so and so was legal. There was no reason to restrict the induction members only to the plaintiffs who filed the suit. In that of the matter, court finds that there is a substance in the resolution made by the learned counsel for the petitioner. Consequently, it is allowed. Okay. Question is annexure G and appellate order. But annexure G is a judgment passed by the 3 plaintiffs.
Now, what is the subject? Exclusion of membership.
Yes, my lord. They wanted to, 35 members wanted to become members. We rejected. Society rejected their name. Only 3% approach court. We have passed the 35 members have applied.
3 persons approach civil court.
Yes, yes.
And they were excluded
Yes.
or inducted back.
Yes. We have included their name.
What did the civil court do?
Civil court said,
Inducted back.
no, it declared that they are entitled to be members.
Members. So
Yes.
inducted them.
Yes.
Inducted back.
Yes, my lord. I have taken them members. I have complied that order.
This appeal is by whom?
Right.
Society.
Page 144, my lord. Decree of the civil court.
My lord, it's by the society.
Suit is filed by the,
Society.
yes, it's society. Appellant is society, my lord.
And learned single judge has inducted
All other members.
on the basis of this.
Oh, so decree passed in civil court. How it is permissible, my lord. Section 31 of West Pacific excludes that. 35 also. Supreme Court says also in recently, my lord,
May I respectfully submit this?
2021
My lord.
Supreme Court, my lord, and pass over the judgment, my lord, on the very question. No judgment is required. Pacific Relief Act,
So-
section 34, 35 is very clear.
All are made voters.
Yes.
All are made voters.
Yes.
Yes, members, my lord.
My lord, we are all admittedly, my lord, the life members. My lord, we were all inducted, my lord, within the common resolution that was passed by the society. The society at no point of time, my lord, disputed the said fact. In fact, my lord, the society itself forwarded our names to the district registrar and sought, my lord, that our names to be included. But it was the mischief of the returning officer then who excluded the names of the 35 newly inducted persons. And that was, my lord, subject matter of the dispute before the competent civil court. Competent civil court looked into the original resolution by the virtue of which 35 members were inducted as the members, held that that is a valid resolution and all the persons are to be the life members of the society. That's how, my lord, the judgment was rendered. The society, my lord, throughout
never said that we were not the members of the society at all. On the other hand, it was the very same society who had forwarded our names to the deputy registrar, my lord, for our inclusion. For a first time, my lord, before the civil court and thereafter, my lord, when the challenge was laid, the society tried to take a different stand from what was earlier taken. That is, my lord, made part of the writ petition papers, where the society, my lord, was with me, and they said that we are all the members, and I have produced, my lord, along with Annexure B, the resolution, and Annexure C, my lord, by the virtue of which my names have been forwarded. Now the society cannot turn back, my lord, on the said nominations.
My lord, the issues may be seen, my lord, at page 105.
But kindly take page 144, decree of the trial court. What it says. But I can understand the civil court declared that the resolution is for no. Civil court says, my lord, page 144. Page 144, my lord. Decree of the civil court. That is very important. Suit filed by the plaintiff is hereby decreed with cost of 500. It is ordered to be declared that letter dated 7/12/2004 issued by the first defendant is void, illegal, and cannot be acted upon on the rights of the plaintiffs, and restrain the defendants, their agent, servant, anybody on their behalf from conducting an election, other administrative function without allowing the plaintiffs or the scheduled society until they are disqualified, nor their membership has been cancelled as per the procedure known to law. Yes, we have complied this. We have taken them as members. We have not denied that. Subsequent to this decree, we have allowed them. We conducted election, inducted as member. But the question now is whether this decree for declaration passed under section 31, 34 and 35 of the Procedural Act is a judgment in rem to hold that not all members will become, unless the decree is not declared as not a judgment in rem. But section 31, not very important, section 34 of the Pacific Relief Act. The cancellation of the instrument, section 31, 32, 33, 34, 35. This is the chapter 5 pertaining to the cancellation of the instrument. What civil court passed decree? 7/24/2004 is null and void, and plaintiffs therein are entitled to become members. Yes, I will read the chapter 5, section 31, 32, 34, 35. If any person against whom written instrument is void or voidable, and who has reasonable apprehension that such instrument is left outstanding may cause him serious injury, kindly note it, may sue to have it adjudged void and voidable, and the court may, in its discretion, so judge it and ordered it to be delivered up and cancelled. If the instrument has been registered so and so also, shall also send a copy to the decree of the officer so and so, and such officer shall note and instrument contain the book's cancellation. Then, my lord, over required benefit to be restored, compensation to be made. That is, I don't read, my lord. Then 34, chapter 6, discretion of the court. Any person entitled to a legal character or to any right as to any property may institute a suit against any person.
Plaintiffs before the civil court were inducted or kept out of?
I have inducted.
Inducted.
We have inducted.
They were kept out.
But I'm society. I'm making submission. They have been inducted.
But then you have passed separate resolution for inducting others.
But that is denied by the district registrar. That has been questioned before civil court. Civil court said 7/12/2004 order. Kindly see the judgment passed by civil court, and page 144. It is the order passed by the government. government authorities. Unless that order is set aside by the concern, how could
Why you should not follow the order of court of law?
Not a Supreme Court recently examined this question, examining 31, 34, 33, 35. Judgment passed civil court is only judgment in persona. It cannot be called as judgment in rem.
15/11/2003 set aside by the civil court.
No, my lord, 15/11/2003 is upheld.
My lord, that has been upheld by the trial court.
Yes, my lord. It is upheld, my lord. It is
That's why I
upheld.
said my lord may see the issue.
It is upheld, my lord.
Not 5.
7/12/2004 is upheld. All the plaintiffs therein are become members. We have complied with the decree. I will not deny that. But the question is, persons who are not parties to the suit, can it be not judgment can be extended to them is the question.
So other petitions were also enrolled pursuant to 15/11.
Please.
Correct, my lord.
Please.
It
And
is
my lord, the
enrolled.
society themselves, my
But
lord,
it is
Bidet
a-
annexed
but-
page
yes, my lord.
80.5,
But-
forwarded our names, my lord, saying that we are the newly enrolled members and we must be given the voting rights.
Correct, my
Now,
lord.
they cannot turn back, my lord, at any point of time. And my lord, this resolution has
But I am
been
sorry, my
upheld
lord.
throughout.
What is questioned before the civil court is, my lord, 7/12/2004 order, wherein the government passes an order excluding these members, please hold election. 3 plaintiffs questioned that order. Kindly take, my lord, page 144. What is the decree my lord, passed by civil court? Civil court says 7/12/2004 is declared as null and void.
Where is this 7/4/2004?
Yes, Lord, I have produced that also, Lord. Kindly see. 7/12/2004 is produced before the court. This court, Lord, Annexure F, page 92 is the English translation, Lord. 7/12 is in Kannada, my Lord. The learned, the other member may read in Kannada also. Annexure F, page 91, Lord. Commences from 90, my lord. Xerox copy is not legible. Therefore, Annexure F typed copy 91. 92 English
92 is
translation.
the translated copy.
I'm sorry, my lord. There is a mistake in the date, my lord, in the English translated copy, my lord. It is 7/12, my lord. Not, my lord, 3/12. But I will read the order and translate into English, though it is there, my lord. If your lord permits me, I will read it. It is in Kannada, then I will come to English. Page 91. ಕರಗೋಡು ಎಜುಕೇಶನ್ ಸೊಸೈಟಿ ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿ ಚುನಾವಣೆ ನಡೆಸುವ ಬಗ್ಗೆ ಪೇಜ್ 91. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧ ನೀವು 7/12 ಸಲ್ಲಿಸಿರುವ ಮನವಿಯ ಬಗ್ಗೆ ನಿಮಗೆ ಉತ್ತರಿಸುವುದೆಂದರೆ, ಜಿಲ್ಲಾ ಸಂಘ ಸಂಸ್ಥೆಗಳ ನೋಂದಣಿಕಾರಿ ಮಂಡ್ಯ ಜಿಲ್ಲೆಯವರು ಸೋ 8/11 ಚುನಾವಣೆ ನಡೆಸಲು ಕೋರಿ 37 ಸದಸ್ಯರ ಪಟ್ಟಿಯನ್ನು ಒದಗಿಸುತ್ತಾರೆ. ಇದಕ್ಕೆ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ತೀರ್ಪಿನ ಒಳಪಟ್ಟಿರುವುದಾಗಿ ತಿಳಿಸುತ್ತಾರೆ. ಈ ಪಟ್ಟಿ ಸೀಮಿತಗೊಂಡಂತೆ ಚುನಾವಣಾ ಪ್ರಕ್ರಿಯೆ ನಡೆಸಲಾಗುವುದು ವಿನಃ ನಿಮ್ಮ ಪತ್ರದಲ್ಲಿರುವಂತೆ ಇವರಲ್ಲದ ಇತರ ಸದಸ್ಯರು ಒಳಗೊಂಡ ಚುನಾವಣಾ ಪ್ರಕ್ರಿಯೆ ನಡೆಸಲಾಗುವುದಿಲ್ಲ. ನೀವು ತಿಳಿಸಿರುವಂತೆ ಇತರೆ 35 ಜನ ಪ್ರಕ್ರಿಯೆ ಬಗ್ಗೆ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಪ್ರಕರಣವಿರುವುದಾಗಿ ತಿಳಿಸಿತು. ಅದರ ಅಂತಿಮ ದೇಶ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಗುವುದು. ಅಲ್ಲದೆ ಜಿಲ್ಲಾ ನೋಂದಣಿಗಳು by this order, they are excluded. They approach the civil court. Kindly see now Annexure G, questioning the order dated 7/2/2004. Civil court, my lord, kindly see page 144. Civil court declares that it is restricted to the plaintiffs therein is declared null and void. Page 144, my lord. Suit is filed by the plaintiff is hereby decreed with a cost of 500. Is ordered to be declared that letter dated 7/12/2004 issued by the first defendant is void and illegal. The only question is this, my lord. If my lord says, my lord, if it is judgment, the civil court decrees a judgment in rem, my lord, I have no case. But I will close my argument. That's only the question to be decided, my lord. If your lordship says, my lord, my humble submission to your lordship is, my lord, Annexure G is a decree of the trial court. Its judgment in personam only restricted to 3 plaintiffs, which I have included their name. Whether
Elections are over.
yes, my lord, election is over.
No, the elections, my lord, are
Election is
proposed to
over,
be
my lord.
conducted.
But the
My
question
lord,
before
the
your
dates
lordship
are
is
not
now,
yet announced.
if your lordship says, my lord, the learned judgment is it's confirmed, but I have to include their names and hold election in next occasion. That is the different. I will do that. But the question, legal question is whether the judgment of the civil court is a person in personam or judgment in rem. If judgment in rem, I have no case, my lord. I can't do anything. Supreme Court says no.
What was done by communication at 7/12/2004?
7/12/2004 is you don't include 25 members, 35% member.
They were treated to be not voters.
Yes, my lord. 35 members shall not be included. Then they approach the civil court. Civil court set aside that order. 3 plaintiffs are concerned. I complied it. I filed appeal before this court. Appeal is confirmed. RSA is confirmed. I complied the order. I did hold the election, including their name. I have not disobeyed.
If elections are over, then this will survive or will academically survive?
But the question is now, in the next election, they will enforce this order. If your lordship, unless your lordship confirms it, whether my lord gives a finding that it's a judgment in rem or judgment in personam. Because Supreme Court says, my lord,
May I respectfully submit?
my lord, kindly see
My lord, what transpired was, my lord, the important issue is,
One
on
minute,
15/11/2000,
I will conclude it. 21/4 Supreme Court on the very point, not Supreme Court, not examining the specific fact. Copy. It is a reported judgment, not 21/4 HCC, page 786. Company filed this petition before Supreme Court. Lord, certain DD, certain resolution is declared as null and void.
When the next hearing will take place? Or next election will take place?
2 years nantra, after 2 years.
No, my lord, the returning officer, my lord, is appointed, but the date of elections are not yet declared.
It is already declared,
Perhaps, my lord, in
we have been
2
functioning
or 3 months
after this
period, my lord, the elections.
We are agreeing and Miss Government Advocate agreeing. We take up this for final consideration.
Yes, my lord. My lord, but kindly present state, my lord. The question of law is, my lord.
We'll take up for final consideration on the
yes, my lord.
Tuesday.
Please.
Tuesday.
Very well.
Next Tuesday.
But till that
And
time,
little
Lord,
more
status
time,
quo
my lord,
maintained.
because I have to intimate the department and get instruction.
When do you?
My lord, first
that
week
day
of,
we'll devote
no, first week of July, my
1 hour
lord.
and complete it. It will
My lord,
take
the officers
45
will be, the officers will be returning after the elections, my lord. So I need some time to have a discussion. First week of July, my lord may have this.
July.
Yes, first week.
1st July.
Yes, yes.
1st July.
In the meanwhile, status quo will maintain.
My lord,
Because
the date
question
of
of law,
elections are not yet
it is a
announced. my
pure
lord,
question
and
of law, my
In
lord.
the meanwhile, what?
But I have not included the name. They will file a contempt petition.
No, I have not filed the contempt petition. The elections itself are not, my lord, announced.
We don't grant interim, what will happen?
Right?
If we don't grant any order right now, what will happen?
Lord, they will say, Lord, they will approach this district registrar. I have already, Lord, I hold election. Please don't approve the audit. I cannot even function at all.
No, the election itself,
Under
my lord, is
section
not
12,
declared. I don't
but
understand
under
this
section 12 of the, my lord,
The dates of
the
election, my lord, itself is
registration
not
act,
announced.
society
Only
cannot
when
co-
it is done, my lord,
Sorry,
I
my
will
lord.
be given the voting rights.
section, Lord, 12, approval of the all resolution.
The issue which prima facie surfaces while considering the challenge to the judgment and order of law and single judge is whether the judgment of the civil court determining the rights of the parties before it in the proceedings of civil suit would be said to be a judgment in rem.
Yes.
Also to govern and apply to rights and obligations of those others who though claim to be similarly situated, but not party before the civil court. And whether on the basis of the decision of the civil court confined to the parties as such, learned single judge was justified in granting relief and allowing the petition of the petitioners. Full stop. Appeal requires consideration. It is admitted. The impugned judgment and order of learned single judge state.
Right.
Appeal shall be listed for final hearing, as agreed by all the learned irrevocable parties on 2nd of July.
Yes, great.
Number 25, Nandish Koda GB.
My lord, two writ petitions connected with each other, my lord. Common order has been passed. One more writ appeal yet to be listed before along with this appeal, my lord.
Pardon?
Two writ petitions, my lord, connected with each other. Common order has been passed by the learned single judge. One more writ appeal, my lord, yet to be connected along with this.
To be connect.
Yes, my lord.
Learned counsels.
Writ appeal 1372 of 23. This is the matter pertains to, my lord,
What is to be appealed against?
no orders has, my lord, proceedings has been initiated by the sixth respondent.
But then
pursuant to the
this is
remand.
only sent back to
My
the.
lord, what happened? The respondent 1 to 3 claiming rights under the defective title, in which, my lord, the matter is pending adjudicated before this honorable court in RFA, and interim order of injunction has been operating against the respondents 1 to 3. My lord, based on the defective title, my lord, the revenue records, my lord, effected in their favor of the respondent number 1 to 3 by the sixth respondent. The same has been set aside by the sixth respondent, and the entries has been made in the favor of the appellant herein. Whereas matter is pending adjudicated before the civil court since from 2006, and interim order of injunction is also operating against the respondents.
Who is number 3?
Please, my lord.
Who is respondent 3?
Respondent number 1 to 3, they are.
Number 3, only number 3. Who is number 3? Who is the appellant? Srimati S. Savitha, what is this capacity and status of respondent 3?
They are the petitioners in the writ petition.
That we know. But what was the capacity of the said party appellant before learned single judge? What is the capacity in the controversy?
Yes, their claim on the defective title. Their claim based on the defective title, and matter is pending adjudicated in RFA 1759 of 2020.
So what is the prejudice? It is only sent back for want of violation of natural justice.
My lord, the revenue records were affected by the sixth respondent without issuing any notice to the appellant herein. My lord, the same was rectified by the sixth respondent after issuance of notice to the respondent number 1 to 3. They are the rival claimants. That order has been called in question before this honorable court in the writ petition.
We are not to interfere. Or learned advocate, Mr. So-and-so, so-and-so, then there is nothing, Mr. in this matter. Only it is sent back. We'll clarify that all contentions are open. And
ultimately, it is subject to the result of the appeal, my lord, which is pending before this honorable court.
So this is serial number 25. Writ appeal 1499 of 23. It is delay, but delay is condoned. Everybody is appearing?
Yes.
IA, delay of 25 is condoned as sufficient cause is made out from the supporting affidavit. Then order in appeal. Heard learned advocate Mr. Sandesh Gowda, GB for the appellant, and learned advocate Ms. Neelofar for the learned additional government advocate Neelofar Akbar, respondent state. Full stop. The present appeal arises from judgment and order dated 7th September 23 of Learned Single Judge, whereby the writ petitions, which is a common order dealing with two writ petitions disposing of the same as per the directions issued in the order. Full stop. What was read in the writ petition was to set aside the order dated 17/3/23, 26, 26?
2006. Well.
Wrongly, error. Which is the impugn order? To set aside the impugn order.
Annexure A,
A, my lord.
Page?
My lord, page
in page
40.
number 53,
So what is the date?
17/3/2016.
16. 17/3/16, passed by the Court of Executive Officer, Taluka Panchayat, Anekal.
Yes.
Full stop. Learned Single Judge dealt with the controversy and passed the following effective order, following operative order. This page 6 of this bracket, yellow flag, green flag. 1, 2, 3, 4, 5, 7, 6, full stop. Learned Single Judge found that the order was passed without affording opportunity to the petitioner, opportunity hearing to the petitioner, full stop. Since the breach of national justice was found, the aforesaid directions issued, remitting back the case before respondent for authority, directing the authority to consider the matter afresh after affording opportunity to the petitioner, full stop. The order could be said to be eminently just and proper. No interference is called for, full stop. This court, however, makes it clear that respondent for shall decide the matter afresh on its own merits. Especially right down, looking to the compass of the controversy rising out of the impugned judgment and order of Learned Single Judge, writ appeal itself was taken up for final consideration. That delay wala order take out, not to be transcribed. So then what is the last sentence? On merits, the respondent for, while deciding the matter afresh, decide the same on its own merits and without influenced by earlier order, full stop. It is made further clear that this court has not gone into or expressed any opinion on the merits of the case of the other side, full stop. Appeal is not entertained accordingly.
26 adjourned, number 27, Mr. H.L. Pradeep Kumar.
Respondents appeal. Lord, the petitioner said to him, Lord, filed application in form 1553 before the regularization committee. Lord, meanwhile, Lord, the state, Lord, issued notification under the provisions of Karnataka Industrial Development Act, Lord, for acquisition of land for the benefit of, Lord, the KDB. Thereafter, Lord, the state government, Lord, issues final notification and, Lord, lands have been, Lord, transferred to the, Lord, the KDB. Lord, when that being the case, Lord, the committee, Lord, constituted under section 94 of, Lord, the Karnataka, Lord, Land Revenue Act, Lord, recommended to the deputy commissioner to, Lord, issue grant certificate, Lord, in favor of, Lord, the petitioners. Though, Lord, the land was acquired, Lord, is against, Lord, section 94A, Lord. Thereafter, Lord, the the deputy, my lord, the learned single judge, my lord, without considering, my lord, the provisions of, my lord, Land Revenue Act, my lord, directed, my lord, the KDB to, my lord, pay compensation at the rate of 30 lakhs per acre, my lord, to the petitioner. Lord, you last kindly take page number 48, my lord. The prayer of the petitioner is to, my lord, challenge, my lord, to quash the, my lord, the acquisition proceeding. The, my lord, never the owner of the property. There's no revenue record, there's no grant. Last kindly take, my lord, the impugned order, my lord. Relevant, my lord, portion, my lord, start at page number 29, my lord.
Oh, what is the grievance? What do you say? What is the grievance about this?
Lord, 94, my lord, Land Revenue Act.
94.
Section 94. Lord, I have extracted, my lord, the relevant, my lord, provision, my lord, page number 11, my lord, to my.
Your KIADB.
Please, my lord. There is a bar, my lord, under 94, my lord, to grant land, my lord, which is subject to acquisition. Yeah.
Why you are here?
Lord, they're not, Lord, the petitioner, Lord, not the owner of the property. Their, Lord, applications were rejected, Lord. You'll ask me kindly take page number 208, Lord. English translation, Lord, 216. Their applications were rejected. Though, my lord, the, my lord, learned single judge, my lord, passes order directing KDB to, my lord, pay compensation.
So your land was acquired.
Lord, the government, my lord, the land was acquired, my lord, is for government land. The government has transferred land to the, my lord, the KDB. Petitioner, my lord, never the owner of the property. Is acquired for the benefit of the KDB, my lord. In fact, my lord, the government has rejected the, my lord, the proceedings, my lord, the recommendation dated 22/7/2022, lord, on 6/9/2021, my lord, page number 223. Last, my lord, document, page 223. It is hereby directed that there is no provision to pay compensation or ex gratia compensation to the subject land, since subject land measuring 14.5 acres was basically government land and land acquisition process was completed 14 years ago.
Today is Monday.
Yes,
Monday will take it. There is, why you are challenging, we fail to understand.
Lord, the Deputy Commissioner, Lord, made recommendation on 22/7/2022, my Lord, pay ex gratia compensation to the petitioner. Though, my Lord, land was acquired, my Lord, in the year 2006 and 7. Thereafter, my Lord, in the year 2022, Deputy Commissioner himself, my Lord, reject the, my Lord, the applications of the petitioner.
My lord, and may I make one submission? My lord, I have to verify whether the deputy commissioner, my lord, admittedly, since they say it's a government land, my lord, even we should have been aggrieved by the order of the learned single judge, and even we should have filed an appeal. So I do not know whether, my lord, that process is on.
He is party.
Yes, my lord, 5 to 8.
The recommendation is, my Lord, contrary to the provisions of 94, my Lord, of the Karnataka Land Revenue Act. There cannot be, my Lord, such recommendation. Thereafter, my Lord, the recommendation was rejected by the government. It's only a recommendation.
For what purpose?
because they're never the owner of the property.
Monday. Tuesday. Next Tuesday, delay. Fourth, fifth, fourth. Not clear. Fourth,
Fifth, my lord, put it, fifth.
fifth, fifth, fifth.
For compliance in contempt matters, number 28.
That's for the complainant. Direction not to clear unauthorized encroachment in a public street. The order is dated 28/2023. Subsequently, application, not after filing this complaint, they file an application.
Yes.
But even subsequent to filing of this contempt petition, they file an application, my lords. Even there, my lords, this court has stipulated time, by 11/3/24, that encroachment should be cleared in the public street. Same is not complied.
My lords, the only direction issued by this honorable court is to the process initiated by him, that is the Tashildar, reaches to its logical end by following the provisions of law, and respondent 3 shall make an endeavor to complete the exercise as expeditiously as possible.
Not my apologies. After this order, they themselves file an application for recalling that order. Lordships have clarified that it should be complied within 11/3/24. My apologies, I'm passing this order. IA 3 of 24 was filed. Mr. Matters.
So what is this order?
Note this, in this notes at para 6.1, they sought for recall of the order. This court made it clear. After affording the opportunity to encroacher, this should be complied within 11/3/24. 6.1 notes. Court records the statement made by the learned government advocate. Court observes that necessary exercise shall be completed on or before 11/3/24.
What is this?
But this is the order subsequent to the disposal of the writ petition after the lordship passing a order.
Appeal.
The writ petition notes.
Writ petition.
Yes, in the PI. They file an application for recall of that order. In this order, lordships have clarified this, whatever directions has been issued to clear the encroachment in a public street, it should be complied by 11/3/24.
Can you file contempt of this order?
Notes, I will file a rejoinder notes because after this contempt,
The only
this order is
that
passed.
is,
Wait. Because it is contempt, any order can be brought. In any matter.
Notes, my,
You are alleging contempt of which order in the present matter?
notes, the main order itself, After filing of this contempt petition, this is a subsequent event notes. Subsequently, they file an application.
In different matter?
Same matter.
Same matter.
Same matter. That is the submission notes. After the disposal of this writ petition, they file an application for recall of that order. By that time, we had already filed a contempt petition.
7
This is 1/3/24. Contempt was filed on 12/2/24. The original
Same
order, yes.
Same matter. So, same matter.
that's this, the prayer in the contempt petition is against the order dated 22/8/2023 in writ petition number 17550.
Notes, I will modify that prayer also because the court has modified that order. I will modify that prayer also if necessary, but they can't escape under that guy's notes. This order is continuation to order 22/8/23.
Take instructions, my lords.
Take it. 24th June. Learned advocate Ms.
Pramodini Kishan.
Rest for time to take instruction. Stand over to 13th June.
Please.
At 29. Ravindra Gajanan Pulle.
May it please my lords. It's about the declaring the order reserve notification which came to be withdrawn. For that, I had already placed at annexure
My
Q.
preliminary submission is flawed. The very writ petition was filed, was premature and on a intra-departmental communication. During the pendants, there was an order of rejection which they sought to be included in this petition by amending the petition. Even that order passed by the Deputy Director of Mines and Geology is a revisable order. Even if the petition is amended, the very writ petition is not entertainable because of the availability of alternative remedy under Rule 53 of Karnataka Minor Mineral Concession Rules.
My submission, my lords. Based on an order passed by the Deputy Conservator of Forest, requesting the Deputy Director. The revision will not lie as against the Deputy order of the or communication passed by the Deputy Conservator of Forest. So revision doesn't lie, my lords, as required under Rule 53. So herein what happened was in way back in year 1929, my lords, a gazette notification passed by His Highness Maharaja of Mysore, reserving that as a village forest, which came to be withdrawn and declared as a fodder reserve. Thereafterwards, no such gazette notification was made available in the archives as well as in the office of the Deputy Conservator of Forest or Conservator of Forest or Principal Chief Secretary, everybody, it was kept hidden. Later on, with great persuasions, petitioner could come to know that such a gazette notification has been cancelled, which I have produced on obtaining under RTI at Annexure T at page number 115, my lords. So the entire basis on which the Deputy Conservator of Forest has communicated to the Deputy Conservator, Deputy Director to stop or suspend the quarry lease as also the stone crusher license are nothing short of suppression of the material facts before my lords. This honorable court in an earlier proceeding, man. It's a clear case of suppression of facts at the hands of the departmental officers, that is especially at the hands of the 7th respondent, Deputy Conservator of Forest. And based on that, Deputy Director proceeded to direct me not to carry out quarry operations. And a suspension order was passed. And thereafterwards, on the earlier occasion, learned government advocate submitted that no, there is an inter-office communication.
Today you are carrying out the operations?
Till today, I am not, my lords. I have stopped because by virtue of that suspension order, I stopped. Now, in 2015, it is the very same Deputy Conservator of Forest who has given me forest NOC. Based on that, environment clearance certificate is issued and I was operating.
So you're challenging which order? It must be appealed.
Annexure.
Page 34.
No, Lord, in the original writ petition, it is intra-department
Communication.
communication. Lord.
That is produced along with my amended writ petition at Annexure V, my lords. In the amended writ petition, because there is one office note is found, my lords, that though my lords were pleased to permit me to amend the writ petition, there was no specific order passed, so that the office has raised an objection that without an order passed by my lords, we have submitted the amended writ petition, my lords. I pray for excuses, my lords. So this, I may be permitted to.
Some order is passed. Some order is required to be passed.
No, only maybe oral order is also in.
Now, what is challenged is annexure A and C. Annexure A is, my lord, at page number 30.
Amended petition is taken on record, my lords. I have made everything clear, my lords.
It is a intra-departmental communication.
Yes, my
and-
lords, they are,
And annexure C produced at 40. This is a letter written by Deputy Conservator of Forest to the.
Continue after recess or some other day.
but if it is continued, please, my lords, please, my lords.
Next matter, not, and correspondent, they need 2 weeks time to file objection. Then there is
Submission, ma'am.
340 days.
Submission, my lord.
Submission.
Please, my lord. I may kindly be permitted to submit the background of this case, my lord. On the last occasion, my lords are pleased to pass an order on daily orders. And last point number 4 and 5, I may kindly be permitted to read. In course of hearing, however, it is stated by learned government advocate that stoppage order of query activities has been passed against the petitioner. Number 5, in view of the subsequent development, learned advocate for the petitioner wants time to amend the writ petition, stand out so and so. Pursuant to this, I have filed an amended writ petition, my lords. On 18/3/2024, incorporating paragraph numbers 14, 15, 16 of the grounds, my lords, and the prayer, my lords. One document is also produced that is dated 30th September 2023, wherein an endorsement appears to have been issued by the deputy director. The last paragraph of the endorsement says that I need to obtain forest clearance under Rule 8(2) of KMMC rules, my lords, which reads like this, my lords.
Will issue notice. Heard learned advocate Mr. Ravindra Gajanan.
It has already been
Notice
issued, my lords, and the learned government advocate appear,
Where is the notice?
and
There is no notice.
28th February 2024.
So notice is issued. So objections are filed,
No,
you file it.
just now they have
But
filed
in the meantime,
amended
my lord-
petition. My preliminary submission is blood. Now, what is challenged in this petition is annexure A, C, and B. Annexure A is intra-departmental communication. Annexure C is interdepartmental communication. Annexure B is an order passed by the Deputy Director of Mines and Geology.
it's not an order, it is an endorsement. Don't confuse. What is the difference between an endorsement and order? You plus understand and make a submission.
Let him submit. Annexure D is,
I am not submitting to you.
annexure D is what?
Annexure C.
C.
Annexure C is,
Deputy Conservator of Forest.
it is a letter written by Deputy Conservator of Forest to the senior geologist.
So there is no decision so far.
So initially, there was no decision, Lord, as on the date of filing this petition. Subsequently, they have amended by incorporating this endorsement issued by the Deputy Director of Mines and Geology. If they are agreed by this endorsement,
Where is that?
Annexure B, in the amended petition.
Annexure B,
B,
amended.
yes,
It is by Deputy Director, Bengaluru Rural District.
yes. If they are aggrieved by this decision, Lord,
Proposal, it is requested to submit a proposal to the government to obtain
obtain.
suitable direction.
If they are aggrieved by this order, let them file a revision. Lord, revision is available under 53. Rule 50.
Where is the decision? Decision is not taken, no decision taken. Pro-
Decision on the letter A and E. May I draw your lordship's kind attention to annexure V, wherein reference is made with regard to the letters produced at annexure A and C. Annexure V in the order itself.
So,
Annexure V may kindly be perused.
so endorsement dated 30th September.
Yes. In that, Lord, kindly
September.
peruse the reference.
So their revision is available.
30th September, my lords.
So revision is available.
No, my lords, it is not an order. What is available or what rule 53 of KMMC rule says, I may kindly permit it one sentence. Any person aggrieved by an order of the competent authority. There shall be an order. It is not an order. It is only an endorsement. And the top of this letter, my lords, it is mentioned as himbaraha, means an endorsement. It is not an order.
So
And-
here normally you are using the words endorsement and order.
Endorsement or order, Lord, in this, if we read the body of this letter, they have considered these two letters and the competent authority has arrived at a decision and directed the petitioner to obtain forest clearance from MOA.
But the last paragraph, I may kindly be permitted to read, there is no order. It is only a suggestion. The last, I mean, in Canaries, it is clearly mentioned, my lords, I may kindly be permitted to read. ಆದ್ದರಿಂದ ಅಂಜನಾದ್ರಿ so and so ರವರಿಗೆ ದೊಡ್ಡಬಳ್ಳಾಪುರದ ತಾಲೂಕು so 8 ಎಕರೆ ಮಂಜೂರಾಗಿರೋ ಕಟ್ಟಡ ಕಲ್ಲು ಗುಣಗತಿಗೆ so and so ಕರ್ನಾಟಕ ಉಪ ಖನಿಜ ರಿಯಾಯಿತಿ ನಿಯಮಾವಳಿ 94ರ ನಿಯಮ 8(2)ರಂತೆ ಅರಣ್ಯ ತಿರುವಳಿ ಪತ್ರವನ್ನು ಪಡೆದು ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿದೆ. It has been informed to obtain forest clearance as required under Rule 8(2). It is not in the form of an order. Basically, my lords well aware that if an order is to be passed, an opportunity of being heard is to be given, as per the principles of natural justice. In the absence of this opportunity, anything endorsement or a letter or some communication cannot be said to be an order within the meaning of Rule 53, my lords. And moreover, that deputy conservator forest is not a subordinate officer to this deputy director, my lords. Only KMMC rules revision would come into play if in the hierarchy of the
DMG, Department of Mines and Geology are involved. Here outside that scope, Deputy Conservator of Forest, who is an All India Service Officer, my lords, not a subordinate to Deputy Director. How a revision is maintainable? Even before the joint director is the next to promote a higher officer than senior geologist, deputy director, joint director, additional director, and director. That is the hierarchy.
Under section 214 of CP Simlat, order is defined. The formal expression of any decision of the civil court, which is not a decree. Here, Mlad, upon considering two communication, the competent authority decided not to permit the petitioner to continue quarry operations. There is a decision on the part of the competent authority and issued an endorsement directing the petitioner to obtain forest clearance.
Department.
Where is your amendment?
I have already carried out the amendment. I have already filed on 18th March 2024, my lords.
Where is that? But where is the amendment?
The amendment, I have filed the amended writ petition itself, my lords.
Where is the amendment?
Paragraph number.
Which amendment you are seeking?
I am seeking paragraph number 14, 15.
Which are the prayers, which are the paragraphs, which are the amendments you want to incorporate?
Yes, my lords.
Where is that application?
Application IA number 3, my lords.
IA number?
3.
3.
IA number 3 of 2024.
But where is that? What is to incorporate in petition? That I want to incorporate this paragraph. This
only the grounds I sought for
this order.
Only the grounds I have sought for inclusion.
Where are the grounds? Where are they?
So that is only the challenging this annexure V.
Where is that also? Where is that also?
I have not filed, my lords. If need be, I will file, extract everything which has been incorporated here in my lords.
Well, this is not the way to file the amendment. Writ petition.
The background is that, my lords, that order was not communicated to us during the course of hearing.
We are only asking, where is your amendment?
That's only I sought for permission in the morning.
Without amendment, how can you submit an amended petition?
That's how the office note was raised.
Office is irrelevant now. Now we are asking, where is your amendment?
Pursuant to the order passed by my lords, which is incorporated in point number 5 of the daily order, I just proceeded that in view of subsequent development, learned advocate for the petitioner wants time to amend the writ petition. Stand
Where is-
over to 20.
Again, where is the amendment? Where you amended?
I number 3 I have filed. Along with that amended writ petition I have produced.
Where is the amendment? We don't know. You readily produce amended petition, but where was the amendment?
So I'll again,
We hope that we are understanding. what we are
I'll seek the permission of my lords.
Amended petition is rejected, since there is no amendment formally produced to be considered by the court. It is open for the counsel for the petitioner to submit a fresh, proper application seeking amendment.
Please, my lords.
This is not the way. You can throw anything without showing to the court what you are going to file as amendment. Yes. You file and then we'll consider.
Next week, my lords, it may be posted. Next week.
You file and after the proper amendment application is filed. the
I'll be filing within
registry
3 days,
may-
my lords.
Registry may list the petition.
Please, my lords.
Sixty-seven.
Could I appear for the complainant?
That VH series.
Please. I have filed my affidavit, my lord.
File. What about penalty?
Lord, my submission is, so far as para 3 is concerned,
Yes.
so far as para 3 is concerned, that may be kept open. Because, my lord, if we succeed, we have to. Statutorily, he is liable to pay.
No, I've been bona fidely pursuing this matter. I've run on 2 rounds of litigation. Before the Supreme Court also, they have refused to grant interim stay. It's not that I was simply thinking about the matter. And this penalty, my lord, it probably increases 3,000 to 4,000 rupees per week.
From the date of registration, it starts.
Yes, correct. But
Now we are debating about the past penalty.
It is deposited or not?
my lord,
Penalty is deposited, not
no,
deposited.
it is imposed. That is what it is showing on the internet.
Imposed,
I am
not
to- I am to pay that.
Not deposit.
Deposited. It happens only when I register.
This penalty towards not registering the vehicle. Penalty
Well, what
for
happens
not-
is-
Not registering.
Within the first 30 days, temporary registration. is
Penalty
given.
for not registering the vehicle.
Please, after the expiry of temporary registration of 30 days.
The present contempt petition. Arises in view of the non-compliance of the directions, non-compliance of the judgment and order of the this is an writ appeal number 191 of 23 and LI appeal, whom I has pleaded and sought to be contended by the contempt petitioner. The background is that paragraph. The Ministry of Transport and Highways, Government of India, introduced Bharat series registers and trademark, which was the facility made available. This was the facility made available to the limited categories of defense personnel, employees of the central government, state government, public sector undertakings, and private sector companies which are having their offices in the state or union territories. Four or more states or union territories. The Commissioner of Transport, Bengaluru, thereafter received notification dated 28/12/21. In line of the aforesaid notification, to register the new non-transport vehicles of the persons excluding private sector employees. The petitioner challenged the said notification dated 20th/12/21 before learned a single judge, contending that the exclusion of the category of the private sector employees was arbitrary, and that the said class of the employees shall also be extended the benefit of registration of BH series for their vehicle. Paragraph. Learn a single judge set aside the said notification dated 20th/12/21 insofar as it excluded the private sector employees, and in writ appeal, the said judgment and order was confirmed. That is out that the present petitioner has filed the contempt application, alleging that the authorities are not permitting to register their vehicles in the BS Bharat series. Learned Government Advocate, Mr. Mahindra. In course of the consideration of the contempt application pointed out that the SLP is already preferred before the Supreme Court against the judgment brought under control, under the contempt jurisdiction. He therefore submitted that the petitioner may not be permitted to, that the authorities may not be forced to act as the subject matter is seized with the Supreme Court. Paragraph. When the contempt petition comes up for consideration today, there figures on record an affidavit dated 27th May 2024, filed by the complainant one Ranjit KP, son of Sri KK Pithambaran, who has inter alia stated on oath as under, and quote this green flap, paragraph 2, I submit that as suggested by up to special leave petition. Full stop. In view of above statements submitted on oath, whereby the complainant petitioner would be depositing the would be registering the vehicle and would be paying the full lifetime tax, road tax in respect to the vehicle, this contempt petition does not book any further consideration. As per the affidavit, the complainants shall act as per the affidavit and amendments made to get his vehicle registered and pay the road tax subject to outcome of the special leave petition before the Supreme Court. Paragraph. On the basis of the on the basis of what is submitted in paragraph 3 of the affidavit, from a learned advocate for the complainant, Mr. So and so submitted that the respondents have levied a penalty of rupees 2,29,751 on the ground that the vehicle was not registered even after the expiry of the period of temporary registration. It was submitted that the said penalty is unjustified and may not be levied. Full stop. While the said aspect travels beyond the scope of the contempt jurisdiction, nevertheless, the court is inclined to consider the said aspect to the limited extent in the context of contempt jurisdiction, in the context of exercise of contempt jurisdiction only. Full stop. There is no gainsaying that the complainant had the benefit of the decision of the learned single judge and the division bench. And in that view, it could be said that the complainant was justified in not getting in waiting for compliance of the justified to wait for compliance of the directions by the authorities. However, it is a different thing that however the said aspect culminates now as above, full stop. In the totality of view, therefore, comma, the complainant totality of view, the authorities may not take any coercive steps. Or in totality of the view, in totality of the view, the vehicle of the vehicle of the complaint shall be registered without insisting of payment of penalty.
Subject to the petition, not because it
goes
may be
without
kept
saying that
open,
the-
not penalty may be kept
Goes
open.
without saying that all the above providences will remain subject to outcome of the SLP, including the liability to pay the penalty.
And my lord, the lifetime tax, my lord, the refund, lord, if I succeed in
Refund
the
is
SLP.
entitled. If
Not paid, you have not paid.
No, if I have to pay now, once I pay,
No, we have said that without insisting.
No,
for
he
it.
is
no, not the
asking for
penalty, my lord,
lifetime.
I'm submitting about the LTT.
So you are paying what?
Complete LTT, lifetime tax I'm paying now. In the event of me succeeding in the SLP,
In case the
refund has to
in
happen.
case the authorities, in case the petitioner complaint in case the outcome of the SLP is in favor of the
Please.
complainant, comma, the authority shall refund the excess amount.
Much obliged.
Grateful.
Shall register the authority shall register the vehicle of the petitioner in BHC.
K
A series.
series, my lord.
KA series in normal course.
Normal course.
In normal course in KS, which series?
KA series, Karnataka registration.
KS series.
Yes.
KS series.
Yes, much obliged.
The contempt precedent stands disposed of in the aforesaid terms.
Obliged.
Pass over matters. Number 4, Srimati Leela.
Your Lordship, I appear for complainant. This is the matter. This is the matter wherein your Lordship, your Lordship directed them to get this pass certificate.
What happened?
They have issued.
Good. The directions of learned single judge for issuance of pass certificate in favor of the complainant petitioner stands satisfied as in course of the hearing today, learned additional government advocate Ms. Pramodini Kishan produced copy of the caste certificate, copy of which is also given to counsel for the complainant. Full stop. It was stated that the officers concerned were present in the court and they complied with the direction of learned single judge by issuing the caste certificate. Right?
Yes, please. Sir.
Contempt proceeding stands closed, has not survived.
I'm grateful, madam.
Number 6, Mr. Nagaraj NR. Mr. Nagaraj NR.
Number 6. Learned advocate for the petitioner was absent in both the calls, in the first session as well as in the second half. The writ petition could have been dismissed for want of prosecution. However, in larger interest of justice, to stand over to 3rd of June.
Number 14, Avinash Gowda, GS.
Please, your lordships, Lords, I apologize for not being here in the first half. In the instant writ petition, Lords, I have sought for a direction of mandamus to direct the second authority minutes, which in this case minutes is the mining department minutes, the senior geologist, to extend the currency of my lease till 2025 minutes. Now, I have to be candid, minutes. For this writ petition, minutes for a direction of mandamus, it ought to have been preceded by a representation to this authority, minutes. That admittedly has not.
You want to make representation now?
Please, minutes, may I, if I seek my lord's indulgence to see if this.
For that purpose, you have filed petition.
Minutes, this has happened by oversight.
Now Sugar quoted saying that I have omitted.
I apologize.
Very, make a representation.
Minutes, may I request your lordship, it can be, if the petition can be treated as a representation, minutes, if at all, if that is possible.
Even otherwise, not
The prayer in this writ petition filed under Article 226 of the Constitution is to direct the second respondent to issue. Direct whom? Which authority? To issue the senior to direct the senior geologist, Department of Mines and Geology, Chikkaballapura, to issue a supplementary lease deed for a period of 30 years from the date of original grant of lease, which was 19 to 2005. It is further read to direct the very respondent to permit the petitioner to conduct the quarrying activities till 27 to 2035 by extending the period of lease as per the first paragraph. In course of the hearing, when the court put a query on it, counsel, Mr. So-and-so petitioner, as to whether before filing the present petition to seek the writ of mandamus, the petitioner has approached the competent authority with a request or not, learned counsel was entirely at his receiving end and fairly considered that the petitioner had no occasion earlier to approach the competent authority with regard to his grievance. Full stop. It is right principle before the court could consider the issuance of writ of mandamus that there must be a demand in form of request by the party before the authority. Full stop. Unless the party has approached the authority first, straightway writ of mandamus could not be asked for. In that view, in that view, acceding to the request of the petitioner, is permitted to approach the competent authority in relation to the grievance raised in this petition and the prayer made herein. Full stop. If such representation of the application is made, the competent authority of the respondent shall consider the grievance of the petitioner in accordance with law and take an appropriate decision.
May I ask for it to be
Within a period of
considered 4 weeks, my lords, I'll make it
4
tomorrow.
weeks.
But it's a
12 weeks.
It's a lapsed lease. The petition itself is not maintainable. Now they are coming up with this prayer.
Forget. This court does not express any opinion on the merits.
Yes, very
But
great.
he's very clever. You are very clever. We
Because it's a
appreciate it.
lapsed lease, Milord.
Great.
It is clarified that the decision which may be taken shall be strictly in accordance with law and on merits. Full stop. This court has not expressed any opinion, nor has gone into the merits of case of the petition.
Very great.
Yes, number 30.
What is your name? What is your good name?
Aditya Bhatt. minutes.
Don't take in headers.
Please, my lord.
COVID started in March 2020. But prior to that, there was 11 months time for which they have not explained any reasons.
Where is your IA?
I am not, I, 115. Page number 105.
Where is your IA?
Lord, page number 115.
15.
I'll review petition.
I'll not come in the way. But order is passed on 25th April 2019. Whereas the review petition is filed in the month of June 2020.
So IA 1 of 2020, heard learned government advocate Sir S.S. Mahindra for the applicant state and learned advocate Mr. S.Y. Shivalli for the respondent. Full stop. The present application is filed seeking to condone the delay of 304 days, which has taken place in filing the present review application. The supporting affidavit spells out the reasons for passage of time leading to delay. It was inter alia stated that initially the decision process was guided towards filing of SLU petition to the Supreme Court. However, subsequently it was to figure review application. Time was consumed in such deliberative process. Full stop. It was then stated that the file was allotted to the Additional Advocate General in the month of June 2020. Details were furnished. Thereafter, the files were given to the Office of the Advocate General. The record was voluminous. It was submitted. Time was further taken in discussion and deliberation. Full stop. Incidentally, paragraph it was stated that the period the time which passed by before the review petition would be filed after the above process, coincided with the pandemic period when the COVID-19 was at its peak and the affairs in the society were at virtual standstill. Full stop. It was submitted that it is in this slide that it is in this view that the review petition could not be filed and delay of 304 days took place. From the reasons given, it could not be said that the passage of time was culpable or that the government authorities were indolent or negligent at any stage. Full stop. The passage of time was attributable firstly to the decision-making process and thereafter the COVID-19 period. Full stop. Paragraph. Sufficient cause is made out to condone the delay of 3 and 4 days. Delay is condoned, application is allowed. How? Order of Learner Single Judge dated 3rd March 23, which is brought under the contempt jurisdiction by filing this petition required the payment of cost by the respondent to the complainant to the tune of rupees 50,000. Today when the application comes up for consideration, a memo was filed by the respondent. Memo dated 30th/5/24 was filed by the respondent, inter alia stating that the cost of rupees 50,000 is paid to the accused by the respondent to the complainant by way of demand draft number 887818 dated 30th/5/2024. Also, the said memo is taken on record. Full stop. The demand draft has been physically handed over to learned counsel for the complainant, which is acknowledged by learned counsel for the complainant to be handed over to the complainant. The contempt was
Twenty-nine 11/2023. No one is appearing on behalf of accused.
HC Ravindranath.
Ravindranath has filed the wakalat and he has undertaken to comply the orders of this honorable court on 29/11/2023. Madam.
somebody is appearing, then I will wait. Somebody is appearing.
Yes, sir.
Counsel for the
Last 3 occasions he has not appeared.
counsel for the respondent is not present.
There's transfer of Kata on the basis of registered gift deed.
Awaiting his presence and assistance. So must hand over to. We'll give short date, 13th June.
Number 33. R. Hemant Raj.
This
The-
order also has been complied. To date has been complied.
So he's appointed.
The appointment order. It's in Kannada.
He's appointed or not appointed?
He's appointed.
Evidencing the compliance of the order and directions passed by learned single judge in order dated 27 September 23. whereby the respondents were directed to consider the petitioner's case and complete the appointment process within outer limit of 3 months, learned additional government advocate Ms. Prabodhini Kishan has produced copy of the order dated 15/3/20. 30/5/24, showing the compliance and has stated that the petitioner is given appointment. A copy of the said order is also made available to the learned advocate Mr. So and so for the complainant. He is satisfied with the. He is satisfied that the directions are complied with. In that view, in the above view, proceedings does not survive.
One request,
They are closed and disposed of.
one request, they are not show the place of work in the order.
It was the grievance raised that the place of posting is not.
That is not the only,
Full stop will be open for the complainant to approach the competent authorities seeking the appropriate orders, requesting for appropriate orders for posting.
please.
Case number 34, Mr. Rohan Veeranath Sigdi.
For the complaint. I appear for complaint.
Writ appeal, my lord, may be called along with writ appeal 1382 of 23. The preferred writ appeal 1382 of 23, my lord, may be called along with it. Called writ appeal, my lord, preferred writ appeal 131382 of 23. You have produced writ appeal. It may be called along with it. So together writ appeal number.
Kindly date may be fixed, my lord. Date may be fixed, my lord.
This contempt petition shall be filed with writ appeal number so and so and so. Shall be posted with writ appeal number so and so on 3rd July.
Please, great.
Number 35, SB Mukanappa.
Appearing per accused number 2,
complaint in this case,
weeks
my
time,
lord.
my lord. Accused number 2, weeks time, my lord. Counsel is unwell, man. Accused number 2, counsel is unwell.
Counsel is argued. Please argue.
No, no, my lord.
Another counsel.
Please.
We saw the counsel is arguing. You are also counsel and you are also arguing.
Proxy counsel.
So what do you want?
Next week. Time, please.
2nd April, 2nd July, sir. As requested on behalf of the respondent.
Number 36, is KV Narasimhan.
I appear for the complaint.
I am appearing for A1 and A2.
Unless the matter related to the writ appeal connected to this is posted on 5th of June, may be taken up on the same day, my lord.
Filing the affidavit of both A1 and A2 are present before the court. A1 and A2 are present before the court. Filing the affidavit are only the document.
So anyway, they were directed to remain present. They were directed to remain present. Respondents were directed to remain present.
Notice was issued in the last date, my lord. Notice was issued in the last date.
Respondents were directed to remain present.
Summons had come for them to appear.
Did the court direct them to remain present? Then why you are bringing unnecessary? You are there to assess the court. We are only concerned with the compliance of the direction, not with the presence of the party unless required.
My only humble submission. A1, Mr. Ravi Teja is wrongly been arrayed as a party.
We are not concerned. We are concerned with the compliance. Don't introduce the parties to the court unless the court is directing them to remain present. Now tell us what is it complied with or not.
I want to file my affidavit and
do it then. When you are complying, you are filing affidavit.
ready. Copy has been sent.
You are the officer of the court to submit. No need to bring the.
My lordship, one humble sub.
It may be taken up on 5th, my lordship. Senior is not available. He's just.
Not available. So let
I
us see
also
what,
filed a writ appeal and
what is
there
it, what is your
It is
reply?
posted on 5th, my lords. They both are connected now.
both have filed the writ appeal.
They're reinstated,
Their writ appeal has been posted on 5th, it seems.
posted.
No, both the writ appeals are clubbed, my lord.
No,
In the morning, is another colleague appeared.
the direction is to reinstate the petitioner.
Yes, my
So
lord.
you are reinstated,
No. I mean, we have filed a writ appeal against the order of the single.
writ appeal is filed. So when the writ appeal is going to come on
Fifth.
board?
Their writ appeal is posted on 5th itself.
Both have filed writ appeal.
They have clubbed it in there. That's what another.
Both have filed cross,
Mine emergent notice has been issued.
but both have filed.
In the last date of hearing, my lordship, both the matters are connected. Clubbed. They are clubbed.
Stated that in respect of the order under contempt, both the parties have filed their respective cross writ appeals, full stop. This contempt application may be listed along with the writ appeal number so and so, so and so, and so and so, so and so.
Great.
On 4th of July.
The writ appeal number 245.
Give the number.
My lords, 5th of June, my lords. 5th of the next week.
5th of
Yeah.
June, 5th of June.
Great.
5th of June is too early, Mr.
The writ
Week-
appeals are posted on the
week-
said.
Hmm?
The writ appeals are posted on the said.
On that, 5th of
That is.
Grateful.
Number 37, to Virupakshaya PH.
Happy for the petitioner. That's the direction of the Honorable Single Judge Manoj is at page 37, Manoj. Directing the respondent accused Manoj to consider the request of the petitioners Manoj for grant of dwelling houses and also to issue Akupatras Manoj in their favor. The order was passed Manoj on 22nd of February 2023 Manoj. To consider Manoj their request within a period of 3 months.
In this matter, Your Lordship, what has happened is about 113 petitioners have come before the court. Previously also, there were 2 sets of writ petitions of a different dweller. Apparently, there are about 1,000 dwellers totally.
Little loud.
There are about 113 petitioners in this matter, Your Lordships, in the order that has been passed. And this order is, they are seeking for regularization of these slum dwellers. In fact, what has happened is there were other 2 previous petitions also, different petitioners in this matter. And totally, I'm informed, I'm instructed that there are about 1,000 slum dwellers that are there. In fact, and there's also a high tension wire that passes by, and that is against the rules to regularize because it is danger to the life of the people who reside below that thing. However, these people are living in hutments, and all this, there's a measure has been drawn by the jurisdictional Tahsildar. Now, Your Lordship, with the ensuing elections, none of the officers in the field are available. So 4 weeks' time is required so that we can come up with a.
Request of learned government, additional government advocate, the job, send over to 15th July would do. 15th July.
15th July.
Great.
Number 38.
My lord, I appear for the accused person, my lord. May I seek for 3 weeks accommodation to file the response, my lord?
3 weeks.
Grateful.
Already the court has directed to issue the appointment, but it's yet to be not issued appointment.
That is to be issued. Now, my lord, the selection process is by KPSC, not by us. They are not parties to the petition. Therefore, we are helpless, my lord. We can't do it.
Against the third respondent, my lord, he's the running the institution.
What is the direction?
Appointment. One. English in the order annexure AM, Lord, page number 34.
Wait. 3 weeks.
Grateful.
One month, within 1 month. they
Have
have
you,
to-
Mr. Counsel, you filed the statement of objection?
My lord, I will file it today, my lord, along with the wakalat. I am just entering appearance today, my lord.
My lord, they are going to be, if it is, get it.
My
followed,
appearance
my
may
lord.
be recorded, my lord. I
Within
am
1 month,
filing the
the order is.
wakalat.
ga-
Take up, we'll keep it on 1st of July.
Grateful.
First.
Not, my lord, this is one, my lord, give the shortest date, Your Worship.
This is shortest.
No, my lord, because of this is a appointment, my lord, appointment order, my lord. This is 2016 notification.
In our perception, the short date is different. If you want, we'll give.
My lord.
You want shorter date?
He
Yes,
claimed to be a physically challenged person
Finally.
and
Finally
certificate is
shorter
found to be fake, my lord.
Finally, you want shorter date?
Yes,
Yeah.
Your Worship.
No, my lord. He is physically challenged person, fake certificate produced.
No,
That is the
please,
issue.
That is,
Listen.
all
Fake
matters
certificate
over,
produced.
all matters over in writ petition.
11th
Argue
July.
there. Your Worship.
11th July.
Grateful, my lord.
My lord,
Grateful.
not my lord. My lord, earlier is,
Earlier.
my lord, kindly be,
So we have different perception about the shorter date
my lord.
than the lawyers. Therefore, don't ask any shorter date to change the date. Okay?
This,
First
the-
July.
next
Grateful.
year, next month, Your Worship, kindly we get any
Next
date.
is not
Next month,
possible.
any
Lot
date,
of
Your Worship.
matters are coming, you are aware about.
My lord, they will, if it is get it.
Again, it will reach at 5 o'clock and you will ask for 4 weeks. So better to come on first.
Ready noting matters, SEMA 39. Mr. Ganpati Bhatt.
This case, my lord, I am appearing for petitioner. The short point for consideration before this court is, my lord, the date. Kindly see ink page number 17 annexure A. Quarry lease has been granted on 30/12/18/3/2011 with effect from 30/12/2003 for period of 10 years. This date is very important because the computation of the date is the question before this court. Therefore, my lord, 10 years has been granted. That is, my lord, valid up to 30/12/2013, my lord. The petitioner has made an application for renewal of the quarry lease before the authority as per, my lord, annexure B. Sorry, annexure C, my lord. Ink page number 54. Your lordship can get that copy. That is annexure C, my lord, ink page number 54. That is, my lord. Sorry, annex ink page number 63 is the renewal application.
That is also not correct.
Annexure D. That is dated 30/12/2013. Ink page number 63.
53.
63. 663, my lord. Annexure D. Last, my lord, 30/12/2000 seal is there at bottom side of that application. That is on 30/12/2013. Renewal application has been made. A typed copy is at 67. Then, my lord, the petitioner's application has been rejected on the ground that, my lord, the petitioner has not made application within stipulated time under Rule 21(2) of the KMMRC rules. On that ground, it is rejected. That is, my lord, annexure E, ink page number 75, translated copy 76, my lord. They rejected only on the ground that is application has not been made within time. Translated copy, I am permitted to read, my lord. Ink page number 77 is the 70 last parameter. It is required, got it, my lord? Ink page number 77. That is, it is required to submit application for renewal of lease for period prior to 90 days from ending date of said quarry lease as per provisions of 21 of the KMMRC amendment rules 1994. But you have submitted an application on 32 expiry of lease period in respect of the application claiming renewal of quarry lease. This is the only ground for rejection.
Rule 28.
Rule 20, I'll draw your lots of certainty. Rule 21 also I'll come because this is the date is very relevant. Rule 21 2, my lord. The two, every application for renewal of quarry lease to quarry non-specified minor mineral in the land belonging to the state government which has not been notified under Rule 8B shall be made in Form R to the competent authority on or before 90 days from the expiry of the lease together with certificate. This is, my lord, the rule. My respectful submission before this honorable court that subsequent to that, I have made application before the revisional authority saying that that is within the stipulated time because, my lord, last day, that is 29th is Sunday and 30th, and computation shall be made from the next day. Same similar circumstances, para 2. Then I'll draw your lordship's attention to operative portion of the order. The factual controversy is very brief. The petitioner was granted license in accord with the provisions of the Karnataka Regulation of Stone Crusher Act 2011. The license was said Act 1899 has been incorporated for the purpose of excluding the first in series of the days and for the purpose of including the last in the series of the days. The word from will have to be read into the last part of subsection 1 of the section 4 of the said Act 2011. For computing the period of 3 months, the starting point is the date of expiry of license, and it is from the said date in the background of direction that the period of 3 months will have to be counted. My lord, the execution of quarry lease, my lord, kindly see, is dated 30/12/2013. Application is not in dispute to made on 30/12/2013 because 29th is Sunday. In view of this, my lord, on execution, if it is 31st 1/1/2004 has to be considered execution by virtue of this judgment, and 20 computation of delay. That's all. This honorable court has clearly held that to how in view of this, my lord, my respectful submission, 21 minutes.
So what was 9(1) in that decision?
Please, my lord.
Section 9(1) of?
That is provision section 9(1) of that earlier 1899 Act for the words as whether it starts from the date of the computation of days.
Let us say the language is identical, perimeter here. Language of this rule 21 and section 9(1) relied on by the judgment which you are referring to, whether the language is identical?
Yes, my lord. That is from used, but that act I have not brought.
Bring it.
I'll bring. Please. I'll bring. Sorry, I'm extremely sorry.
Tuesday?
Yes, my lord.
Tuesday. Which is the act?
Please, my lord.
Which is the act?
Act, my lord. This is.
Meantime we'll go through.
Karnataka regulation, sorry.
Stone process.
That's stone process.
But Tuesday, keep it on Tuesday.
Please.
It is there in that book only. In that book only.
1899 in that. Much. Seventh. On 7th, my lord, instead of 4th. 7th.
7th June.
Please.
In this matter, we have filed statement.
Yes.
Then keep it on 11th.
Please. Much.
This matter, we have filed statement of
much.
And 2 judgments also. Covered by 2 judgments also. It is there along with state.
Statement of December 40, Mr. Shailesh SK.
Lord, the 5th respondent is a stone crusher, and his stone crushing unit is next to my land where I am cultivating there, my lord. License has been granted to them, and I am told there has been a renewal of the license in this matter. My lord, an inspection has been carried out at the instance of this honorable court, and the inspection report is also produced. There in the inspection report, which is done by the Pollution Control Board, it is mentioned at page 5, special page 5, specific observations. There it mentions
Lord, the petitioner agricultural land was located adjacent to the stone crusher. It is observed that part of the land located adjacent to the road has not been cultivated, and other part of agriculture land So what was the report? My lord, what was the report of the? Lord, the inspection reports mentions that my land, because I also stay there, that is situated in very adjacent to the stone crusher unit, which is done by the fifth respondent. As per the inspection report, when the pollution control board went to inspect the premises, on both days, the stone crushing unit was not in operation. So they could not make an assessment. But however, they have made an observation that deposit of stone crushing powder in the agricultural land immediately located adjacent to the stone crusher boundary has been observed. This has caused both air, water, and sound pollution to the petitioner. Therefore, I am before this honorable court. Now, subsequently, there has been a renewal of the license. When granting the license, one of the criteria is that it should be a 1 kilometer, any stone crushing unit should be 1 kilometer away from the private land. Then they renewed the license after report. After report, they have renewed the license.
Yes, they have renewed the license. Apart from that, my lord, I have also sought. I have also sought for a relief, asking them to take direction. While granting license, before renewing the license, petitioner has not been heard also in this matter, and renewal has taken place. That is my grievance, because my house and my agricultural land is situated very adjacent to the
premises, which is in violation of section 6 of the stone crusher unit.
Lord, order dated 14/2/2023 may kindly be paid in this very repetition. There was a direction to conduct spot inspection. In pursuance of the same lot, a joint spot inspection by Revenue, Department of Mines and Geology, Pollution Control Board, and in presence of the quarry pressure holder and the petitioner was conducted on 27/2/2023. That report is placed on record along with the statement of objections. There is no violation of the provisions of Stone Crushing Act. And this has been granted strictly in compliance of section 6(2) of the regulation of stone crushing. And moreover, Lord, renewal is not, we have not decided on the renewal application.
Renewal, you know,
Extension is not given.
rejected.
Not rejected, Lord, he has to submit the extension. We have not taken any decision on the renewal application. It's pending. It is deemed extension till 33 we have.
So for orders.
Next Wednesday.
My Lord, only one submission, if may be permitted to make. Pollution Control Board has given them an authority, has said that there is no objection for grant of license.
It's for the government to consider after it has been recommended by the Pollution Control Board. It's for the government to consider for the renewal of that.
Please, ma'am.
Number 41. Query for
Yeah.
petitioners, my lord. My lord, writ of mandamus. My lord, in this writ petition, my prayer is very limited to consider my representation for a direction to the respondents to complete the road construction which was started in the year 2018. My lord, in the year 2018, the respondents started construction of a road between two villages, that is Bhavani Bijalgaon village and Mudhol B village in Kamalanagar Taluk, Bidar district. When the construction of the road was halfway through, the respondents have abruptly stopped it for the reasons best known to them. Thereafter, they have never taken up the completion of the road. So, my lord, the people have been facing much hardship.
to use the road. Even the half of the road which was constructed, they are full of potholes.
Full of
Potholes. My lord, since the year 2018, my lord, the people have been facing much hardship.
it is already initiated. Process of widening, acquiring. Then they'll do it.
Pardon, my lord?
They'll do it. You find out whether it is motorable or not. 4 weeks is too much. Election. Second July.
Number 42. Says suo motu writ petition.
July.
Number 43. Mr. Dalwai Venkatesh.
Petitioner. Last time, my lordships issued notice and granted its status quo order. The respondents will have to come back with the answer to the petition. The government and the National Highways authorities. But this pertains to acquisition of the land in and around Mukambika Temple, Kollur.
So you want. What is rejected? Some temple was.
It's a Kollur Mukambika Temple. The road is National Highway has undertaken widening of the road, which runs exactly next to the temple. The 1200 years old history for this temple. One of the grievance of the petitioner was that we filed an objections under section 3C of the National Highways Act.
And those objections were considered?
There is no communication to us. There is no communication. If she can place it on affidavit, my lords, then I will have a copy of this. No. Right, put it.
Fourth will do.
Or fifth instead of.
Or
fourth.
11. June.
What's interim order is there till today onwards. Same may be kindly extended.
December 44,
There is an interim order granted, Your Lordship.
Interim orders will continue to operate till the next.
December 44, Mr. Ravindra Gajanand.
Please, my lords. Please, my lords. I am a query lease holder, my lords. Way back in the year 2006, I was granted a query lease to extract ordinary building stones. And the period came to an end in 2011, my lords. It was initially granted for a period of 5 years, which came to an end in 2011. In the ordinary course, I ought to have filed the renewal application 90 days earlier to the expiry of the lease period, which was not done. Belatedly, renewal application was filed, which came to be rejected by the competent authority. Even in revision also, the order passed by the competent authority was upheld, and it settled there itself. Now, by virtue of an amendment dated 17/3/2023, substituting Rule 8A with retrospective effect, including expired leases, they are eligible for deemed extension for a period of 30 years from the date of original grant. It is in explicit terms, it has been mentioned in Rule 8A, sub-rule 2. I may kindly be permitted to read, my lords. All the quarrying lease or licenses granted before the commencement of the KMMC amendment rules shall be deemed to have been granted for a period of 50 years in respect of specified minor minerals, and for a period of 30 years in respect of non-specified minor minerals from the date of original grant, comma, subject to subject to establishment of mineral availability and workability of the quarry, and also subject to the condition that all the terms and conditions of the lease or license have been complied by the lessee or licensee. Provision is added, which is most important for my aspect, my lords. Provided that mining leases of minerals which are classified as minor minerals by the central government, wide notification number SO 423 dated 10/2/2015, shall be deemed to have been granted for 50 years for an area already granted under such lease, and be considered as quarrying lease or license as the case may be, comma, very same the words are used, subject to establishment of mineral availability and workability of the quarry, and also subject to the condition that all the terms and conditions of the lease have been complied by the lessee or licensee. The subject to the condition for both the things are one and the same, verbatim. The next proviso is important to me, my lords. provided further that, comma, the quarry lease or license which are granted before 12/8/2016 and the period of such lease or license expired before commencement of these rules shall be considered for extension of period under the provisions of this rule. So this is the benefit of deemed extension is applicable to all expired leases, subject to one condition that they should have been granted earlier to 12/8/2016. With this, my humble submission is I am entitled for the deemed extension, which is pursuant to latest Honorable Supreme Court decision in Nirmala Ben's case, that it is deemed extension is infusing new life into the existing lease. It's only a prolongation of the lease deed. So for that, I have produced the decision passed by Honorable Apex Court at Annexure E at page number 75, my lords. So herein, by virtue of the decision passed by Honorable Apex Court, I am entitled for deemed extension for a period of 30 years from 2006 to 2036. Despite my inability to get a renewal, because erstwhile rule 26 says that initial grant period of the lease is first 5 years and renewal of 5 years in 4 terms. That is 20 years plus 5 years, 25 years is the erstwhile rule, my lords. But herein, they have granted 30 years period, my lords, deemed extension. But I also made a request, my lords. It is produced at Annexure B on 19/12/2023. After coming to force this 17/3/2023 amendment, that I may be given the benefit of deemed extension, for which Annexure A is an endorsement issued by the competent authority, stating that in view of sub-rule 8 of Rule 8A, you are not eligible, which is ex facie not in accordance with law. For the two reason is that they have cited the statement in the statement of objection filed by the state government has said that 3 decisions have been produced, Annexure R1, R2, and R3. All those decisions are passed earlier to 17/3/2023. And they say that Rule 840 then, I think in force, is relied upon. Now, by virtue of amendment dated 17/3/2023, Rule 4 is omitted. It is not there. The requirement to make an application earlier, or it should be live lease, or any such other things, similar things, are totally taken out. That's the reason I'm entitled for the deemed extension. And for the statement of objections, I have filed a rejoinder, my lords, a detailed rejoinder I have filed, which is on 27/5/2024, I have filed, my lords, stating that 8A4 is totally omitted, which is not applicable, and the benefits of deemed extension is applicable to all expired leases. As per the proviso, second proviso to Rule 882, my lords, expired leases, very explicitly it is mentioned, my lords. So the rejoinder, I have so stated, my lords, in the opening sentence itself, at paragraph number 3, my lords, undisputedly the only precondition seeking grant of deemed extension
Yes, what do you say? The reply is filed. Reply is filed.
Yes.
It is that.
I have taken for contention in my statement.
Yes, it is filed.
First is regarding maintainability. Regarding maintainability, they have a remedy under 53. The competent authority has passed an order. Secondly, my lord, this is a case of rejection of renewal. It's an expired lease. After lapse of 2.5 years, they have filed renewal application. They ought to have filed a renewal application 90 days prior. Both are revision was rejected on 12/1/2017. And this petition was filed in the year 2024, after lapse of 7 years. Therefore, my submission is, it's a lapsed lease attracting sub-rule 8 of Rule 8A. It is covered by the judgment of this honorable court. May I draw your lordship's attention to sub-rule 8 of Rule 8A.
Rule 8.
Rule 8A, sub-rule 8 of Rule 8A. The provisions of this rule notwithstanding anything contained therein shall not apply to a quarry lease or license or mining lease of the minerals now classified as minor minerals with a notification so and so. It's granted before the date of commencement of Karnataka Minor Mineral Concession Amendment Rules 2016, for which renewal has been rejected or which has been determined or lapsed. Here is a case, Lord. It was lapsed. Though they have filed a renewal application of lapse of 2.5 years, it has been rejected. It has been confirmed in revision. Therefore, Rule 80A8 is squarely applicable to the facts and circumstances. Okay. And one more aspect of the matter is that, Lord, as on the year of rejection, that is 2017, 2016 rule is in force. In order to, Lord, to save that, to seek deemed extension under Rule 80A4, Lord, they have to fulfill the conditions stipulated under sub-rule 4 of Rule 80A. It is squarely covered by the two judgments of this coordinate bench of this Honorable Court, which I have produced along with the statement of objections. The amended provision of 17(3)2023 is not applicable for the rejected leases.
So this is appeal, or let the appeal be heard finally. We'll hear it finally.
Please.
Date may kindly be. Short date may kindly be given.
Date will be.
Please, my lords.
Serial number 46.
46.
81 years. 46. Time for the complaint.
10th.
Your submission, my lord. Serial number 56, my lord.
Serial number
Election
57, my
petition.
lord. Investigation has been stayed, 57, my lord. I'm for the respondent.
I'm for the appellant in 57, my lord.
Next week, my lord, if investigation has been stayed, my lord. The PMLA.
57. All right, when do you?
Next week, any date, my lord, if it is possible, my lord.
What is it about?
Sorry, my lord.
What is the subject matter?
The PMLA, my lord.
PMLA.
Yes.
11th?
Yes.
Serial number 56, my lord.
Interim order may kindly be extended in that matter, my lord. Serial number 57.
57, stand out to 11th June. Interim order.
Serial number 56, my lord. 56.
All office of this and
Serial number.
You remove the office.
Serial number 56, my lord. That's an election petition. Kaile out on Monday, my lord. Take it up on Monday, my lord. Serial number 56, my lord.
What do you?
Election petition, my lord.
My lord,
Election
it's a
petition.
cooperative
Serial number 50,
society
cooperative
thing.
election
My
petition.
lords, we had filed our schedule. They had sought for time to file objections.
Not an objection, my lord. Some document we sort of time for filling this document today. We're ready to, tomorrow we'll file it as a judiciary. Kaile out on Monday, my lord. We'll engage the senior.
Cooperative society elections, my lords.
Keep it on, take up on Wednesday.
Monday, my lord. Monday, my lord. Monday, my lord.
No, no, Monday, no.
Yes, we have scheduled the elections.
No, no,
We are holding the
there is a
election.
reason.
So the only point is, Manoj, they wanted to be conducted earlier. We have given a schedule to hold the elections, Manoj.
Same matter.
Same matter, Manoj.
No, my lord. There is a difference. Adala. 56, sir.
56 only. We have given a schedule to hold the election.
That is a scheduled on November, my lord. That is why we object, my lord.
Your colleague gave last.
Please,
Yes, my lord. Day before yesterday, my lord.
Produced, never ever published before this.
No, my lord. So therefore, in fact, my lord, in view of this, we have lost 3 months because of the parliament election. That is the whole thing, my lord. We'll try and do the election at the earliest. If my learned friend has any other suggestion, if he has given alternative calendar, if he can do it earlier, my lord, let him point out, my lord. We'll work around that.
Monday.
Monday, my lord. Obliged.
Monday.
Monday.
Serial number 65, my lord.
48, my lord. Serial number 48. Despite of the direction given by this honorable court on the last date of year, there are no office objections. It is non-compliant.
Now,
Yes, make the guidance.
dates will be given by Learned Court Office. Anything?
Nothing.
My lord, one submission, my lord. Serial number 53, it's a KIDB appeal, my lord. Before the learned single judge, they said they don't want the land for cricket. Before my lords, they're saying that they want the land. My lord, as senior citizens, my lord is pleased to fix the date for today. Could it be taken up, my lord, next week, my lord? The reason is there's a stay operating against us for 15 years, my lord.
For the appellant there, after hearing him only.
No, they made a wrong submission before my lords when they
there are some two
were granted the
applications, my
stay.
lord, they may be allowed, one for my lord amendment and another for additional.
12th July.
My lord, little earlier, my lord. If the reason is, my lord, that before the learned single judge, they have said that the acquisition officer has said that they don't want the land. Now, this is land for cricket, my lord. The cricket authority say they don't want the land. KIDB is doing a project of 2,000 acres nearby, which is empty. My lord, my land, my lord, is 15 years under cloud. I'm now 80 years old.
My lord, he has, my lord, gifted that land, he has no locus standi to question.
No, that, my lord,
And lord, after hearing, my lord, the respondents only, my lord, the order of interim order of stay has been granted. my lord.
their submission was factually wrong.
On merits, my lord.
Their submission was factually wrong. Therefore, my lord, there's a change in circumstance. I request, my lord, any date, my lord.
Any date?
No, I mean, at the earliest, my lord.
Interim order, interim order.